Good morning, all. This detailed assessment of costs hearing is in the matter of CFI 079-2023 before the Registrar Ayesha bin Kalban. The claimant is represented by White and Case. Lead counsel is Mr. Robbie Jackson. The first defendant is represented by Habibul Mullah, and lead counsel is Mr. Stephen Docherty. Thank you, Madam Registrar.
Thank you, Lena. So Mr. Jackson and Mr. Doherty, I've gone through the skeleton arguments. I've gone through the bill of costs and the notice of commencement, as well as all points of disputes on the replies. I've also gone through the costs order, as well as the actual judgment by Justice Lemire on the 15th of May. So you don't need to spend too much time taking me through the reading materials. I think I have a good grasp of what's on for today. Mr. Jackson, would you like to go ahead just briefly as a summary to take us through your arguments?
Yes, thank you, Registrar. As you will have seen then, the total amount claimed in the bill of costs is around $135,000, and that represents 50% of the costs incurred by the claimants in the Part 8 proceedings to which the detailed assessment relates. As you will have picked up, the reason we only claim 50% of the costs of the Part 8 proceedings rather than 100% is because when making the costs order, Justice Lemire applied a 50% discount to the costs the claimants are entitled to recover. There are 11 points of dispute which the first defendant has raised in respect of the claimant's bill of costs. The first 2 points of dispute are general points about the claimant's costs, and the remaining 9 are more specific objections to particular line items. I'm in your hands as to how you want to proceed, Registrar, but my suggestion would be that it's probably most efficient if the parties address you on the general points first before we turn to the more specific objections, because there are some points of principle in the general objections.
Right, that's fine.
Thank you. I'll deal with points 1 and 2 of the objections first then. And it's probably easiest to look at these in the claimant's reply to the first defendant's points of dispute. So if we start with point 1, which is at page 51 of the bundle.
51?
Yes.
Okay, yeah.
So you should see there point 1. And there are essentially 2 points made by the first defendant in relation to point 1. First of all, that the hourly rates of the claimant solicitors are too high. And second, that there's been an unreasonable allocation of work between the fee earners working on the case. Now, each of those points we say is wrong, and I'll deal with them in turn. So in terms of the hourly rates, the claimant solicitors' hourly rates almost all fall within the indicative hourly rates, as per the guidance set out in Registrar's Direction number 1 of 2023. And I've set this out in my skeleton argument. If you could turn to that, please. The relevant paragraphs are 23 to 24, and those are at page 900 of the bundle.
Right.
And I won't spend too much time on this, Registrar, as the direction was authored by you. But obviously, this sets out the indicative hourly rates, which are effectively guidance when considering the rates likely to be acceptable to the court when assessing costs. And you can see at paragraph 24, I've copied and pasted those there. And then if one goes to paragraph 30 of my skeleton, the table there provides a comparison of the indicative hourly rates and the hourly rates of the claimant solicitors. And almost all of them fall within the guidelines. In some cases, they're significantly under. In a few limited cases, they're slightly over. So just by way of example, for trainees, lawyers up to 5 years, the indicative hourly rate is $651 an hour. We have charged $655 for one fee earner, and then for the other two, it's $605 and $365. If one looks at the 10 years and partner rates, those are both significantly below the guideline hourly rates for all fee earners. So the suggestion that our hourly rates are too high in my submission doesn't have any basis. And neither, we say, does the suggestion that there's been an unreasonable allocation of work. Now, of course, in every case, there needs to be some division of labour between the more senior fee earner working on the case and the more junior fee earner, because a balance needs to be struck between the more senior fee earner providing supervision and decision making, and the more junior fee earner carrying out what I might describe as the legwork. The question in this case is whether the division that we adopted was reasonable, and we say that it was. And one can see what the actual division was if we turn back to the claimant's reply to the points of dispute, again at page 51 of the bundle. And you'll see, Registrar, in the claimant's reply under subparagraph 1, it notes that the bill of costs shows an approximate 65%, 35% split between associate and partner time. So this is not a case where 100% of the work, or the majority of the work, or even 50% of the work has been carried out by a partner. Instead, just over a third of the work has been done by a partner. And we say that's entirely reasonable. So for those reasons, my submission is that point 1 should be rejected. I'll move on then to point 2. And you can see this, Registrar, from page 52 of the bundle, just over the page.
Mm-hmm.
And there are a number of points taken in relation to point 2. And I'll come back to exactly what the first defendant is saying. But in summary, we say this point of dispute is fundamentally misconceived and is an impermissible attempt to rewrite the costs order that was made by Justice Lemire. And I'll briefly explain why we say that. The Part 8 proceedings, as you will have seen, involved 2 claims. First of all, there was a claim for a declaration that the first defendant had been replaced as the general manager of the second defendant, and that's what the judge called the removal claim. And second, there was a claim to set aside an agreement between the second and third defendants, and also an order for an account of profits was sought, and the judge called that the set-aside claim. The claimant succeeded on the removal claim before the judge, but for the set-aside claim, the judge agreed with the first defendant that that should proceed under Part 7, not Part 8. So on that aspect, the claimants didn't succeed. Now, when it came to costs, the judge considered whether he should make an issues-based costs order, awarding the claimant the cost of the removal claim and the first defendant the cost of the set-aside claim. But he very sensibly decided not to do that because it would be very difficult practically to work out what costs were attributable to each claim. So instead, he took the approach, as you will have seen, of awarding the claimants their costs of the Part 8 proceedings as a whole, but with a 50% discount to reflect the fact that they hadn't succeeded on the set-aside claim. And the point of doing that was to avoid the practical difficulties of identifying which costs have been incurred for the removal claim and which costs have been incurred for the set-aside claim. And I know you've seen the cost order, but just if I could just refer you briefly to a few parts of it. If we could start at page 110 of the bundle.
110.
110.
110.
And at paragraph 47 there, the judge says the case is not concluded, but a distinct phase of the case is concluded. That's obviously a reference to the Part 8 proceedings. And in the 4th line, the judge says the court can and should determine who is the successful party in the phase of the case that has been heard. Then over the page, at paragraph 56, After noting in paragraph 53 that the claimants could properly be regarded as the successful party, at paragraph 56, the judge says the question then is whether there should be a discount from 100% to represent those parts of the case in which the claimants failed. In my judgment, there should be, and the claimants failed on the substantial part of the case, namely the set-aside claim. And over the page at paragraph 57, the judge considers whether the court might make an issues-based order, but says there are two reasons why that's undesirable. And if we look at the second reason at paragraph 59, the judge notes that an issues-based order would create significant difficulty in assessing the cost to which each party would be entitled. And that's essentially because where one makes an issues-based cost order, one needs to try and work out which issues are responsible for which costs, and that's problematic because there's often overlap, particularly where two claims are being advanced at the same time. And then at paragraph 61, the judge concludes that substantial justice is done by awarding the claimants 50% of their costs to the Part 8 proceedings to date, with the exception of some unsuccessful applications for substituted service or alternative service. So that shows you the judge's approach. What he was trying to do in my submission was simplify the detailed assessment process that's to be taking place today. It was intended to be a straightforward order by which the claimants could recover 50% of the Part 8 phase rather than an issues-based order. And the only question in my submission that the judge left for you to consider, Registrar, in broad terms, is what is a reasonable and proportionate amount for the claimants to have incurred for the Part 8 proceedings? And it follows from the judge's order that the claimants are entitled to 50% of that amount. And one doesn't need to get into what costs were incurred in relation to which issues. But what the first defendant is now trying to do in its points of dispute, and it's repeated in a number of the more specific objections that we'll come back to, is to complicate the process and to circumvent the judge's order by saying that what you, Registrar, need to do is distinguish between the cost of the removal claim and the cost of the set-aside claim. And we can see that from the first defendant's skeleton argument, if we can briefly look at that. If you're working from the hard copy, the relevant paragraphs are paragraphs 8 and 9 to start with. So paragraphs 8 and 9, this actually reflects what we say is the correct approach. So paragraph 8, it said that the registrar must determine whether the costs claimed by the claimants in respect of its Part 8 claim were reasonably and proportionately incurred, etc. And then at paragraph 9, if not, the registrar must determine what proportion of that sum was reasonable and proportionate, and 50% of that amount is the amount that is payable pursuant to the cost order. So far, so good. We agree with that entirely, and that's the approach I've just described. But then if one moves on in the skeleton argument, if you could look at paragraph 22, I'm just going to pick up one example, although there are multiple. What's said at paragraph 22 is that we have failed to provide an adequate breakdown of the work done in respect of each separate application and are in effect claiming 50% of all work done, even where that work is not relevant to the successful portion of the claim. And if you go on, just by way of example, I'm afraid this doesn't have a paragraph or a page number. It's in the bundle at 917. So it's 3 pages on from the page we were just looking at. Nope. And this is in relation to point 2 of the objections. And you'll see at the top there, it says one of the points made is that second, it is clear from many of the itemized costs that they had nothing to do with the removal claim. At the end of that paragraph, it said issues concerning IP ownership relate solely to the set-aside claim and have nothing to do with the removal claim. And then towards, in the second to last paragraph, it said no effort has been made to distinguish the issues. So what you're being invited to do, Registrar, is try and work out what issues are attributable, what costs are attributable to the set-aside claim, and what costs are attributable to the removal claim. And that, we say, is fundamentally inconsistent with the judge's approach. As you've seen, that is the very approach that the judge deliberately avoided, because it creates all sorts of difficulties in working out what costs were attributable to each claim. So, to summarise, this detailed assessment should be a straightforward exercise. But the correct approach, in my submission, is for you, Registrar, to decide whether the claimant's costs are reasonable and proportionate, and the claimants are then entitled to 50% of the reasonable and proportionate sum. And it's as simple as that. And it's wholly impractical and inconsistent with the judge's order to try to decide what costs were incurred for each of the two claims. So for those reasons, my submission is that this point of dispute should also be rejected. That's all I had to say on points 1 and 2, Registrar. As I say, it might be sensible to hear from Mr. Doherty on those.
Would you like to go ahead, Mr. Doherty?
Yes, I'm happy to go ahead. I think probably there are some general points that I need to make before coming on to the specific points of dispute, which in effect frame my submission. So that those points relate, first of all, to the relevant principles, so that we can set the framework for the hearing. But secondly, also the context in which you're considering costs. So that's to take you again to some of the points that arise from both the judgment and the cost judgment and other prior parts of the hearing. If you're happy for me to go through those, I can then pick up on the submissions that are just made on that point of principle. If I can start with the principle, the basis of the order that Justice Lemire made is that costs should be payable on the standard basis. And that's obviously important to clarify at the outset. What he is not saying is that the claimants are entitled to 50% of the costs they claim. What he said is that in principle, there should be a starting point of 50% recoverability, but that still requires the costs to be assessed on the standard basis, first of all. But it also requires the costs to be assessed in the context of the order that the judge made, which is that they are costs of the Part 8 proceedings, as distinct from other aspects of costs in the proceedings. And I'll work through that, but dealing with the relevant provisions of the court's rules, of course, you'll be aware that RDC 38.18 says that in carrying out that analysis, you have to look at two things. One, you may only allow costs which are proportionate to the matters in issue, and on the standard basis, where there's any doubt about whether costs are reasonably incurred, an assumption applies in this case in favour of the first defendant as the paying party, that if there's doubt about reasonableness, if there's doubt about proportionality, it should be resolved against the claimants in this case. 2 points about the effect of the rules in the context of this case. The first is that when one is making an assessment of proportionality and reasonableness, one necessarily has to look at the costs that have been incurred by reference to the matters that were actually decided. So that means you have to look, for example, at whether or not the issues decided were complex, if so, what level of complexity was involved in the issue, whether there is justification for extensive costs being incurred in that context, and that's what tells us whether or not something is proportionate. Second, of course, if you're in any doubt about that, the doubt must be resolved in the first defendant's favour, so you shouldn't allow costs unless the claimants can demonstrate to you that the costs it says were incurred were in fact reasonable and proportionate. And the factors that one needs to take into account are set out in rules 38.21 and 38.23. So were costs proportionally reasonably incurred, and are they reasonable in amount? And in making that determination, registrar, you have to have consideration of all of the circumstances in the case. And what RDC 38.23 tells us is that includes the complexity of the matter. So that's an express requirement to take the nature of the case into account. So breaking the provisions down, the costs that are being claimed have to be reasonably and proportionally incurred, and it has to have been reasonable for time spent carrying out a particular piece of work which the claimants seek to recover. And costs have to be reasonable and proportionate in amount. So they have to be shown not to be excessive. And that is all measured by reference to the complexity of the issues. Which brings us to the broader point we make about the costs incurred in the circumstances of this case. And to start with, and this is page 20 of the bundle, which is the bill of costs itself. It's important to get clarity on what we're saying the figure that is actually claimed as being the time and cost incurred in dealing with this dispute is. The figure that my learned friend cited to you, the 134 or the just under 135,000, that is the 50% discounted matter. The actual amount of cost that was claimed is 269, well, just shy of $270,000. So that's the reference point. One has to look at that figure, work out from there how much of that is reasonable and proportionate. And then once one gets to a reasonable and proportionate figure, you then apply the 50% discount factor pursuant to Justice Lemierre's order. Now, the context in which that 270,000 figure arose was effectively in relation to three live issues at the hearing in April 2024. First was the removal claim capable of being dealt with at that point as a Part 8 claim, and judgment entered on that. Second, the same question with respect to the set-aside claim. And the third question was really whether either of those aspects of the proceedings should proceed as though they had been commenced under Part 7 of the court's rules, i.e. on the basis that they involved substantial disputes of fact and would need to follow on a Part 7 track, providing for witness evidence, document production, and so on. And the outcome of the hearing, as you will be aware from your pre-reading, was that the set-aside claim couldn't be determined as a Part 8 claim, that it needed to proceed as a Part 7 case. So it accepted the first defendant's argument for that portion of the claim. And that's on the basis that the issues involved in the set-aside claim, and I'll come to a little bit of the detail of this because I appreciate this is not necessarily a straightforward case to sit down and get into the issues just by reading the papers. But that was the complex part of the claim. That's why it's proceeded on the Part 7 basis. The first defendant's position is that the claimants only succeeded on a very narrow part of their claim, which is this removal claim. And so the point we make is that the assessment of reasonableness or proportionality will necessarily have to grapple with whether costs were reasonably incurred and reasonable in amount by reference to the complexity of that issue which was decided in the Part 8. So that's the complexity of the removal claim. And to give you a sense of that, if I can just take you to a few bits, first of all, of Justice Lemierre's judgment on the issues. So if we go to page 76 of the bundle.
Right.
We can see in paragraph 39, is a summary setting out what the two claims were about. So what we're calling the removal claim is dealt with in paragraph 39.1. So that was a claim seeking a declaration that the first defendant, Mr. Shehata, should be removed as general manager and replaced by the second claimant. And paragraph 40 explains that that's a claim determined by reference to provisions in the Articles of Association regarding the appointment and removal of a general manager by a resolution of directors at a properly convened and quorum meeting. So that's the removal claim. The set-aside claim concerns whether or not there should be a setting aside of an agreement, which was an agreement transferring or purportedly transferring intellectual property rights in a piece of medical software called Medica Cloud Care from the second defendant to the third defendant. The claimant's own submission on the removal claim is summarised at paragraph 53, which is at page 78.
Right.
Which is that they submit that the removal claim turns entirely on the validity and effect of a board resolution on the 16th of May. The issue is whether the resolution to remove the first defendant needed to be signed by the first defendant. That is a short question of law, which turns on the terms of the Articles of Association and the regulations. So the context of this aspect of the case, which is relevant when you're considering proportionality and reasonableness, is the determination of a short question of law, turning on relatively limited factual background. Indeed, that's why, of course, the matter was progressed as a party in the first place, because in order to be a party at claim, there must be no substantial dispute of fact. The judge then sets out his rationale for ordering that the set-aside claim proceed under Part 7 from paragraph 71 onwards. That's at page 81.
Mm-hmm.
And again, this is to give some context to some of the items that appear on the bill of costs. But what the set-aside claim concerns, you can see at the top of page 82, paragraph 72, Health Insights entered an agreement to sell intellectual property rights to Health Insights Malaysia. However, it is relevant to determine whether Health Insights Dubai owned or had any legal interest in those intellectual property rights. Then it refers to Mr. Shehata's role as a director of Health Insights Dubai and his role in Health Insights Malaysia creating a potential conflict. And the question is whether that transaction conflicted with duties to Health Insights Dubai. And there are several factual issues involved in that concerning ownership, value, impact, and so on. And paragraph 74 deals with factual issues involved in taking an account when resolving disputed facts. And those, in effect, are the reasons why the set-aside claim becomes the Part 7 claim. In other words, the disputed issues concerning the ownership of this program, Medica Cloud Care, was fact-sensitive, and the questions of whether any transactions involving those intellectual property rights conflicted with the first defendant's duties to the second defendant were fact-sensitive issues which needed to proceed to trial. Now, that position must be seen in contrast to how the judge then dealt with the removal claim. So this begins at page 87 in paragraph 102.
Right.
And I won't go through the detail of the analysis, but you can see from a relatively brief skim what the judge is determining is relevant to the consideration of this portion of the claim. So, for example, from paragraph 103 onwards, there's the judge is dealing with the question of authority to remove Mr. Shehata as general manager, and one can see that that involves the judge considering in effect, two provisions of the DCC regulations and also the Articles of Association. So this article is Regulation 74, which the judge sets out provisions of, and Article 22. The next question the judge deals with from paragraph 109 through to 113 relates to the passing of the director's resolution in accordance with the regulations and the articles. And again, what that looks at is certain provisions of the DCC regulations. So those are referred to in paragraph 109. There's reference to the Articles of Association in paragraph 113. And in paragraph 114, there's reference to some of the factual background, which comprises the giving of notice of a general meeting of the company. At paragraph 115, there's reference to factual material, which is Mr. Shehata's email saying that he won't attend. At paragraph 117, there's then reference to the meeting itself having taken place. And then 120 and 122 deal with what evidential weight should be given in effect to minutes of meetings in accordance with the company's articles. And then within that context, the judge from paragraph 124 deals with challenges made to the resolutions. So that's arguments that the unanimous vote of directors was required. And then from a paragraph 127, an argument that the resolution does not need to be signed by all the directors. Both of those challenges, as you can see from the judgment, are dealt with by reference to the regulations and to the articles. From paragraphs 135 through to 153, the judge deals with arguments challenging the resolutions based on the existence of a conflict and based on alleged improper purpose, which again the judge answers by reference to provisions of the regulations and the Articles of Association. So the conclusions on that are paragraphs 146 and 147. And that is the material that then leads to the judge's declaration at paragraph 165 of the judgment, that he was satisfied for the purposes of making a declaration that at the meeting of the board of directors, the directors validly passed resolutions removing Mr. Shehata as the company's general manager and installing the second claimant in that place. And the reason I put it in that context, and the reason we've sought to add the factual exhibits from the hearing to the bundle for today's purposes, is to show you precisely how comparatively little information was required to deal with the Part 8 aspect of this claim, that's the removal claim, as compared with the set-aside application. And I can give you the page references should you wish to take it away. But the documents which were relevant to the consideration of this part of the dispute were pages 704 of the bundle, which is the Dubai Creative Clusters regulations, of which a few provisions were cited by the judge. There's 764, which is the Articles of Association, again, of which a number of provisions were cited. And when it comes to the factual material, it's page 823, which is a one-page notice of a meeting taking place. So this is the 11th of May notice. Page 824 over the page, which is the email from Mr. Shehata saying that he wouldn't attend. which runs to 3 pages, and then 827, which is the resolution itself that was passed. And I appreciate that that's in some detail, but the reason I show you that is that the litmus test for reasonableness and proportionality in the context of this case has to be measured against these issues that were decided on the Part 8 and those documents. The other parts of the exhibits may well have some relevance to the claim as a whole, and in particular the claim that is now proceeding as a Part 7 claim, but ultimately their relevance and the costs associated with dealing with those issues are going to fall to be determined in the Part 7 proceedings following the trial of those issues. So that's the context in terms of the judgment. There's a broader context I wish to take you to, Registrar, in respect of work carried out prior to the 15th of April hearing, which again informs the broader points we make on reasonableness and proportionality. And that relates to the adjourned hearing, which was listed to take place on the 1st of March 2024, initially to deal with what was then a Part 8 claim. And that's the reason I take you to that, is because the bill of costs, as you will have seen, doesn't just relate to the hearing of this Part 8 claim having taken place on the 15th of April 2024, but there's what we say is a attempt to, in effect, recover the same set of costs twice in respect of the hearing that was listed to take place on the 1st of March. And if I can illustrate the issue, I take you first of all to page 863. Which is the transcript from this 1st of March hearing. And one can see that what the claimants had turned up ready to argue at this hearing, and what they had provided a skeleton argument for at this hearing, was to deal with both the removal claim and the set-aside claim. So at the bottom of page 863, we can see Mr. Montague-Smith says, Your Honour, you'll have seen there are 2 parts to this claim. And then at the very bottom of this page, what Mr. Montague-Smith says is, as he terms it, one is a rather more straightforward than the other, we would say, because in relation to one, we have 2 directors calling a board meeting and Mr. Shehata blocking it by not showing up, or seeking to block it by not showing up. Now, there is a very short question there, by whether or not he, as general manager, can prevent his own replacement. That would be a very odd result. It is not the conclusion that you get to from the Articles of Association. And we can see that very quickly by looking at 2 parts of the articles and 2 parts of the regulations. The answer is the board meetings are quorate with 2 directors, and then it is just a majority vote. I'll show you that for a couple of reasons. The first is that this is how the claimants were presenting the issue at the time prior to the order being made, which is that in order to determine the removal claim, all you need to do is look at 2 parts of the articles and 2 parts of the regulations, and that gets you to an answer. So that's relevant, we say, to reasonableness and proportionality, but also in the context of the costs which are being claimed in this case. The second point we make is that the claimants had turned up to the hearing on the 1st of March prepared to argue that short point of law. And having done so, they will have done the work that would have been required when they eventually come back before the court following this short adjourned hearing to argue that point again. And that's context that I'm going to come on to in some of my points of dispute. Now, if we go to 871, one sees what happens at this hearing at the bottom of the page. Justice Lemire, starting with, yes, I have it. He says, I'm going to allow the first defendant's application for an adjournment. The basis of the application is that the defendant has not been served with the claim form. There is a certificate of service has been filed, and there are service documents provided by the claimants, and the translations of that service declaration is ambiguous and confusing. In the body of the document, it states that the server, quote, and then it provides a quote. And the judge says, however, the following page states something else, and the judge reflects that the date in which the documents were said to be served, the 14th of January, Mr. Shehata said to the court that he was not at his home residence on that date. Mr. Shehata said that before he knew the contents of this service document. And then at the bottom of this page, the judge's conclusion, and then over to page 873, is that I'm not able to make a finding that the documents were served on Mr. Shehata, and indeed, on the basis of the material currently before me, I do not make that finding. And again, 2 points arising from that. The first is that the hearing was adjourned because the claimants were unable to satisfy the judge that they'd effected service on the first defendant. So in the broader points, there's going to be a question about the reasonableness and proportionality associated with the costs, not only of this hearing, but of work carried out in respect of service. But the second point is that the claimants had, of course, turned up to this hearing of what they said was a straightforward issue, turning on the articles and regulations, had come prepared to argue that point. They drafted a skeleton dealing with it and were ready to go. And if that was the case on the 1st of March, it should also have been the case on the 15th of April, without further work having to be carried out. And that has a bearing, again, on the reasonableness and proportionality of the overall cost, which cover both hearings, and where substantial costs were incurred across both hearings. And then the final piece of context I wanted to give to you, Registrar, is a few aspects of the costs order. So if we go to page 104, first of all, a reflection on what the costs the judge had in mind were going to arise as a consequence of the Part 8 proceedings, paragraph 17 and 18. In effect, it's the cost of drawing up a claim form, preparing evidence in support of the removal claim, and attending a hearing to resolve the removal claim. The basis for the judge making this costs order, the analysis starts at page 110. And the few paragraphs which I would draw your attention to, paragraph 47, which you've already looked at, is the reflection that the case hasn't concluded, but a distinct phase had. Mm-hmm. And what the judge says, the court has determined the removal claim under the Part 8 procedure. The set-aside claim remains to be determined and will be determined under the Part 7 procedure. The court can and should determine who is the successful party in the phase of the case that has been heard, and the claimant's claim under the Part 8 procedure for declaratory relief in respect of the removal resolution, and their claim to set aside the agreement and require the first defendant to account for any benefit realised. If we go over the page, so he asks then, who is the successful party? Over the page of paragraph 53, the judge says the claimants have obtained one of their claims, whereas the other has not been determined. On this basis, the claimants could properly be regarded as the successful party for cost purposes. And then in paragraph 56 at the bottom of this page and over to page 112, there's the reflection that the claimants failed in a substantial part of their case, that the set-aside claim should be decided under the Part 8 procedure. Significant amounts of time and costs were spent on that argument. And at page 113, paragraph 62 and 63, it said that the defendants are the unsuccessful party in relation to one of the two claims. The other claim remains to be determined. They failed on two of the issues argued at the hearing, requiring them only to pay 50% of the costs, adequately reflects the success the defendants achieved in relation to the set-aside party at issue, which leaves the set-aside claim to be decided. In my judgment, therefore, the right to discount costs, the defendants must pay by 50%. Now, the terms in which the judge frames both paragraph 62 that you have in front of you, but also what we looked at in paragraph 47, where he said the set-aside claim remains to be determined and will be determined under the Part 7 procedure. That's relevant because this isn't a case where you have one aspect of the claim which has been determined and one aspect which has been dismissed. What has happened is one substantive part of the claim has been determined. That's what we're dealing with the cost of at this detailed assessment. One substantive part of the case is yet to be determined, and that's going to be determined in the context of Part 7 proceedings. The aspect of the case which the claimants were unsuccessful at the hearing and therefore justified the reduction is the costs associating with arguing whether or not, as a matter of procedure, the set-aside claim should proceed on as a Part 8 claim or as a Part 7 claim. Now, the reason we say that the distinction between those three issues, i.e. that there are two sets of substantive issues, one is the removal claim, that's the Part 8 claim, two is the set-aside claim, the substantive issues involved in that are the Part 7 claim, and then there is the procedural issue, which is what procedural pathway should these proceedings continue on. The reason we distinguish those is because no orders have yet been made on who should pay the substantive costs of the set-aside claim. Those costs are costs which will be held over to be dealt with as part of the Part 7 claim. And I certainly don't understand the claimant's position at this hearing to be that when it comes to resolving the costs of its Part 7 claim, i.e. the set-aside claim, that it is not entitled to claim any element of cost prior to the 15th of April 2024. I'm sure I'll be corrected if I'm wrong on that. But to the extent it said one can't segregate out costs or not, that's plainly not the case. And in fact, we say that it's highly likely that that's the approach. Not only that the claimants will adopt when it comes to resolving the costs of the Part 7 proceedings, so there is resolution of the set-aside claim, but it's worth reminding ourselves that if we go to page 56, this is in the reply to the points of dispute, and if you look at bullet point 3, what the claimants have told us in that response is that they have sought to exclude those costs. So the first line is the claimants have in their bill of costs excluded costs relating to the set-aside claim only. Now that's obviously problematic because the approach that we adopt at this hearing is to say that costs which relate to the set-aside claim are not costs of the Part 8 proceedings at all. They're costs of the Part 7 proceedings. And not only is it proper to seek to exclude costs which clearly relate to the set-aside claim only, but the claimants have actually told us that that's what they have done. And it must naturally follow that the claimant's intention as a consequence of that is that when it comes to the resolution of costs of the Part 7 proceedings in due course, that they are going to be seeking to claim those costs if they are successful on the set-aside claim. And we say that the position that my learned friend now advances, both in oral argument and his skeleton, i.e. it's irrelevant to the detailed assessment whether the cost claimed in the bill of costs related to the removal claim or the set-aside claim, is both not the correct approach to dealing with this detailed assessment, but is also not the approach that the claimants themselves have told us they have adopted. And the risk that one runs in that context is, in effect, the claimants are seeking to have it both ways. They're seeking to roll some cost into the Part 7 proceedings, which they will presumably seek to claim in due course if successful in the set-aside claim, whilst also saying that in the context of its overall bill for $270,000, you shouldn't be concerned if some of the elements of cost seem to relate to that proportion of the claim. And it's in that context that really there are 2 points that we make when it comes to that overall framing of what we are dealing with when we're dealing with the judge's order that 50% of the costs of the Part 8 proceedings should be payable. And it's probably worth looking at the order the judge actually made. So if you go to page 101, paragraph 1 says the defendant shall pay the claimants 50% of their costs of the Part 8 proceedings to and including the 15th of April 2024. Those words of the Part 8 proceedings set the relevant scope of what the order covers. So what the judge is not saying is you get all of the costs incurred irrespective of what it related to up to the 15th of April. What he's saying is that you get the cost of the Part 8 proceedings. The Part 8 proceedings is the removal claim. That is the only issue that was dealt with as a Part 8 claim. The set-aside claim, as the judge reflected in the portions of the judgment that I just took you to, is being progressed as a Part 7 claim. As the judge pointed out in his cost judgment, the other claim is continuing. And so those costs of the Part 7 claim, those costs of the set-aside claim, are going to have to be determined in due course. And so if the point that my learned friend now takes in his skeleton, which is different to the point that was made in the points of dispute, we say what one is likely to find is an attempt to recover sums which relate to the set-aside claim only later in these proceedings in the context of the set-aside claim. As I say, we don't understand the claimant's position to be that they are not going to be entitled to recover pre-15th of April costs of the set-aside claim, and that they can't have it both ways. Any costs associated with the set-aside claim must be determined in the Part 7. Those have to be treated as distinct from what is caught by the scope of the judge's order at paragraph 1, which is the cost of the Part 8 proceedings, because those are the costs of the removal claim, and it's only the latter that are recoverable on this assessment. And I'll come on to the detail of that when we get into the bill of costs. But just to round that off, I can say that even if I was wrong about the framing of that, which of course we don't accept, the detailed points that I'm going to make in due course, in particular in the context of point 6 and point 9 of the bill of costs, the issues I've taken you to are still relevant and material when it comes to your assessment of reasonableness and proportionality. Because when one is looking at the unit costs and when one is looking at what time was spent on, one necessarily has to cast a critical eye in deciding whether those costs were reasonably incurred. what the actual units of time were spent doing. And if one can see in the bill of costs that substantial amounts of time were spent, for example, dealing with issues concerning service or issues concerning analysis of intellectual property rights, which are not relevant to what was determined in the Party 8 proceedings, then one can take the view that those amounts of time and those costs were not reasonable and proportionate to the issues in the case, which is what you're required to consider, Registrar, under the court's rules. You have to have a view on what the circumstances of the case are and what reasonableness and proportionality looks like in the context of the issues that were actually decided. And so either way that you frame it, one can see, just stepping back, that the overall bill presented here of $270,000 for what the claimants themselves say was a short point of law, requiring only the consideration of two provisions of the regulations and two provisions of the Articles of Association dealt with at a one-day hearing, is, to put it mildly, excessive. So that's the broader point on in respect of point 2. When it comes to point 1, this is the hourly rates point. At the outset, the point we would make is to say that the reference to the DIFC's guideline hourly rates isn't really an answer to the criticism that we make on this issue. It somewhat misses the point. The issue with rates, in this case, deals with excessive rates being charged for work that ought to have been carried out by more junior lawyers. So the rates are high because the distribution of labour is inadequately done, we say. And to give some examples of that, at page 13 to 14 of the Bill of Costs, where we have attendances on the client, what we find is, in effect, a 50-50 split of time being used. So what one sees at page 13 and 14 is 8.5 hours of client attendance at partner level and 9 hours at mid and subsequently senior associate level. Those are reflected at pages 15 to 16. And this is one example where what we say is it is not necessary, nor is it reasonable or proportionate to have that much day-to-day engagement at partner level, when the appropriate way to deal with day-to-day communications with the client would be to do so at associate level, and that half of client attendances being at partner level is not reasonable and proportionate. And so the partner rates that are applied to that work are excessive, and we say should be adjusted to reflect mid-level associate rates. And similarly, if one goes to page 19 of the Bill of Costs, we get the schedule of time spent on documents. And really 2 points arising from this. One is that we have a similar amount of what we would say is excessive partner time spent on documents. So it's 42 hours in total. And again, that has to take into account the complexity of this case. So that's an excessive amount of time spent on documents, which we say ought to or could have been dealt with at the level of a mid-level or senior associate. And when one gets into the detail of how time is spent on documents, you can also see a similar lack of delegation where work is being carried out at mid-level associate or senior associate level, which could be carried out either by a junior associate, trainee, or paralegal. So at page 26, where we've got Schedule A, there are a series of entries toward the bottom of the page from the 27th, through to the 29th of April, which deal with reviewing and updating bundles. So there are 4 entries at the bottom of the page dealing with bundling. And similarly, if one goes to the bottom of page 29, there are elements of work which are updating case bundles. And we can see that that's work that's not only being carried out by a mid-level and subsequently senior associate, which is Miss Albulaihid, but it's also carried out by Miss Roshan at partner level. And so these are examples, we say, of work consistently being carried out by more experienced practitioners than is necessary given the nature of the work being carried out. And so when we say that the rates are excessive, it's on that basis. It's on the basis that the rates that should apply to that type of work should be effectively rungs down the ladder. In respective points taken by the claimants against the first defendant on that, if I could just deal with them first, I think what's been pointed to is that the first defendant's own balance of partner time suggests that a significant proportion of the overall time was spent working by partners. I mean, the first point it makes that we say that's not really a proper comparison to make in this case. The nature in which the first defendant's solicitors were onboarded was shortly before the hearing took place on the 15th of April. So in that context, it's not surprising, given that there was a short period of time before the hearing, that one would have more senior lawyer involvement, because if you're dealing with things that need to be turned around very quickly and urgently, and you don't have the benefit of time, as the claimants did in this case, given we know how early they were working on a case prior to it coming to a hearing, that it's not a proper comparison that one can make. But the second is that it also fails to address the wholly different order of magnitude of the cost claimed by the first defendant's lawyers and the claimants. The grand total of the first defendant's cost for the hearing of the Part 8 claim was a little over $88,000, as compared with the $270,000 for the claimants. And the partner rates being charged by the first defendant were also considerably lower than the claimants. It was a dirham figure, but it's around $675 per hour. And to put that in context, the total of the first defendant's costs were less than the claimant's counsel's brief fees alone for the hearing of the Part 8. So we do say that the way that work was apportioned by the claimants, given the position that they had, was not reasonable, and that the costs were not reasonably incurred. So that deals with the general points at 1 and 2. I suspect we'll come back to some of those points being made in the context of specific items in due course.
Great, thank you, Mr. Doherty. Mr. Jackson, would you like to say anything in response before we get to the bill?
Yes, just briefly, Registrar, because I'm conscious that we need to get on to the specific items in the bill. There are 3 points I'm going to make in reply to Ms. Doherty's submissions. The first point relates to the effect of the judge's order. The effect of the judge's order in my submission is straightforward. There are 2 phases to these proceedings. There's the Part 8 phase, which lasted up until the 15th of April 2024. And then there's the Part 7 phase, which goes beyond that. What the judge ordered is that we are entitled to 50% of the costs of the Part 8 phase, subject to detailed assessment. Now, Mr. Doherty said he didn't understand it to be our position, that we wouldn't be able to claim the cost of the set-aside in the Part 7 proceedings, insofar as they predated the 15th of April 2024. But our position is that there are two separate phases, and one won't need to get into the costs of the Part 8 phase, insofar as they relate to the set-aside claim, at a later date in the Part 7. So, and one can see that from the order that the judge made. So just briefly to go back to this, Registrar, if you go to the costs order at page 110 of the bundle.
Right.
And it's paragraph 47 again. And I know you've looked at this twice already, but just to underscore the point. In the last sentence, the judge says, the court can and should determine who is the successful party in the phase of the case that has been heard. And then he says, that is the claimant's claim under the Part 8 procedure for declaratory relief in respect of the removal claim, and their claim to set aside the agreement and require the first defendant to account for any benefit realised. So what the judge is saying there is that the Part 8 phase isn't limited to the removal claim that succeeded. It also includes the set-aside claim. And that's reflected in the substantive provisions of the costs order, if we briefly look at those. So page 101 of the bundle. And at paragraph 1 of the costs order there, the judge says that the order made by the judge is that the first defendant shall pay the claimants 50% of their costs of the Part 8 proceedings to and including 15th of April 2024. Now, the date there is important because it marks out the date on which the judge was saying that the Part 8 phase was concluded. So as I say, you have this Part 8 phase up until that date, in respect of which the judge ordered that the claimants are entitled to recover 50% of their costs, subject to detailed assessment. And what will happen at the end of the Part 7 proceedings is that an assessment will need to be made of the costs from that date onwards. But that assessment will not be looking at the costs prior to that date, because those are already covered by the judge's order. So that's the first point. The second point I want to make in response to Mr. Doherty's submissions relates to the context to the removal claim and the set-aside claim. And essentially, the thrust of my learned friend's submissions was that the Part 8 proceedings were not very complicated, and that should be borne or taken into account when you come to consider reasonableness and proportionality. Now, as I mentioned, there are obviously two claims. There's the removal claim and the set-aside claim. My submission, as you just see, is that both are covered in the Part 8 proceedings up until the 15th of April. So actually, this point on complexity is a red herring, because the judge's order wasn't limited to saying we could only get the costs of the removal claim. It's broader than that. But in any event, if I could just deal with some of the principles relating to costs, which are relevant to the reasonableness and proportionality of costs for the removal claim. I've set these out in my skeleton argument. If you could turn that up at paragraph 21.
Yeah.
So I've set out above the general principles about assessment, which you'll be familiar with, and I don't think they're in dispute. But then at paragraph 21 and 22, I've quoted a number of specific provisions of the RDC. So 21, in any claim there will be costs which will inevitably be incurred and which are necessary for the successful conduct of the case. Legal representatives are not required to conduct litigation at rates which are uneconomic. In a modest claim, the proportion of cost is likely to be higher than in a large claim and may even equal or exceed the amount in dispute. That's RDC 38.25. And then at paragraph 22, where a trial takes place, the time taken by the court in dealing with a particular issue may not be an accurate guide to the amount of time properly spent by the legal or other representatives in preparation for the trial of that issue. see RDC 38.26. So in relation to the removal claim, I accept, of course, that it proceeded under Part 8, and it's not as complicated as a full-blown trial of a Part 7 claim. But it was nonetheless an issue that was hotly contested by the first defendant, both on the basis that it shouldn't proceed to a determination under Part 8, and also as to its merits. And you saw the substantive judgment that Justice Lemire gave on the removal claim, and I'm not going to take you back through that now in the interest of time, but he does deal with a number of arguments that were raised by the first defendant as to why the first defendant said the claim shouldn't proceed under Part 8, and also as to its merits. So it's not as straightforward as my learned friend suggests. In relation to the set-aside claim, my learned friend described that as the complex part of the claim. And as I submitted earlier, that is part of the claim which we're entitled to recover for up until the date which the judge stipulated of the 15th of April 2024. So those are the points on the context. The final point I want to make by way of response is on the rates and distribution of work. I'll keep this brief. My learned friend's submission was the rates are high because the distribution of labour is inadequate. And my submission, that doesn't work as a matter of analysis. Rates are either high or they're not, and one just needs to look at the number that's being charged by the fee earner to determine whether they're high or not. That's an entirely separate issue from how the work has been allocated. So as I understand what the first defendant is saying, it doesn't actually take an objection on the figures that have been charged, but it's all about allocation of work. And Mr. Doherty took you through a few specific examples where he said the distribution of work was wrong. I gave you in my opening submissions the overall figure for the distribution of work, and I'll come back to the more specific examples as we go through the bill. But in my submission, it's clear that looking at the overall picture for the bill of costs, the split of work is entirely reasonable. And as I mentioned earlier, it's 65-35%. So those are the points I wanted to make by way of reply to Mr. Doherty's submissions. Unless you are minded to make any ruling on those points or to make any comments, Registrar, I'll move to the actual substantive items.
I'm content to proceed on the basis that we are only going to be looking at the reasonableness and proportionality of the amounts incurred. I will be going through the bills line by line to assess whether or not some of these items could have been conducted by a more junior member of the claimant's firm. So I would say the costs that we will be assessing today are the costs incurred up to the 15th of April, and that's in accordance with the cost order set out in paragraph that was set out in paragraph 1 of the cost order. So if we could move on to the bill, and then we can continue going through each one of the points raised by both parties.
Yes, that's very helpful, Registrar, and I suspect that will make it more efficient now that you've given that indication as to dealing with the specific items, because quite a few of them, I was going to make the same point about them seeking to circumvent the cost order made by the judge in light of your indication. I don't think I need to labour those points. So the first point is the first point, which is a specific objection, is point 3 in the points of dispute. You can see that, Registrar, at page 52 of the bundle.
Right.
And there are essentially 2 points made by the first defendant under the heading point 3. The first point is that the costs of the hearing on the 1st of March 2024 shouldn't be recoverable at all because the first defendant says it was adjourned by the judge after a failure to effect service, and the judge concluded he cannot proceed. And then under subparagraph 2 of point 3, there's also reference to applications to joinder having been improperly made. That's the first point made by the first defendant. And the second point is that the costs of the hearing are duplicative because the hearing was adjourned and relisted on the 15th of April. And we say that each of those points is wrong. The first point is misconceived because, again, it's an attempt to circumvent the cost order made by the judge. The costs of the 1st of March hearing fall within the Part 8 phase of the proceedings, and therefore we're entitled to 50% of the costs subject to assessment. So the only question which goes to assessment is the second point on duplication. And in respect of the second point, we say it's not correct that the costs of the 1st of March hearing are duplicative. And there are 2 points I make in relation to that. The first point is that inevitably, when a hearing gets adjourned, there are additional costs that are incurred. In particular, there are additional costs incurred because all the lawyers have to attend 2 hearings. And there isn't any way to avoid that. And that is why, for obvious reasons, the court tries to avoid adjournments where possible. So the mere fact that there was an adjournment does not mean that the costs are duplicative. That's the starting point. The second point is that it's important to understand that the scope of the 2 hearings was different. And I've addressed this in my skeleton argument. It's at paragraph 35 sub 2.
Right.
So, as I say there, at the 1st of March hearing, the first defendant was acting as a litigant in person. He hadn't filed any evidence or written submissions, and he pitched up at that hearing and requested an adjournment, and there was also an oral application for joinder made by the claimants. But by the time of the 15th of April hearing, the defendants were legally represented, and they had filed an acknowledgement of service, a skeleton argument, a witness statement, and an extensive bundle of documents running to 1,230 pages that they relied upon. So the work required for the 2 hearings wasn't identical. It changed substantially between the 2 hearings. And that's also reflected in how long the hearings went on for. So the first hearing was listed for 2 hours and 30 minutes. The second hearing went on beyond 5 hours. So this is not a case where one can say, well, actually the work shouldn't have been different for the 2 hearings because you'd already prepared for one, and the second one was just a repeat on a different date. The 2 hearings were substantially different in scope, and for that reason, the costs aren't duplicative. That's all I wanted to say in relation to that point. Registrar, I'll obviously wait to hear what Mr. Doherty says.
Mr. Doherty?
Yes. Registrar, a helpful starting point for considering this is the reflection that the judge himself had about the costs that were incurred when he made his cost order. So that was paragraph 67 of the cost order, where he says the claimants have incurred costs of $266,000. That is a substantial amount for Part 8 proceedings, which proceeded only to a 1-day hearing followed by a short adjourned hearing. And it was at that point that he reflected that he was not satisfied that the cost statements filed were sufficiently detailed to carry out a proper assessment. But the judge is quite right to express what we say is clearly surprise at that total bill. One of the main explanations behind that, as I've already alluded to, Registrar, is the fact that counsel's fees for that, as the judge termed it, short adjourned hearing and a 1-day hearing, itself exceeds the total bill of costs for the first defendant by approximately $15,000. I've already taken you to the transcript of the March 2024 hearing. Now, the issues that were being dealt with, the removal claim and the set-aside claim, both were issues which the claimant's position was these do not involve any substantial dispute of fact. You can deal with them now without any further evidence. Necessarily, given that the claimants wanted those issues to be dealt with as Part 8 claims, that had to be their position both at the 15th of April hearing, but also at the 1st of March hearing. So those claims could only be treated as Part 8 claims if they didn't involve substantial dispute of fact. The issues involved in determining whether or not there was a valid resolution of directors replacing a general manager by reference to Articles of Association and the DCC regulations, that issue did not change one bit between the 1st of March and the 15th of April. The issues involved were identical, and that's reflected by both submissions made at both hearings, but the skeleton arguments which were filed in materially similar terms for both hearings. If I can break down the reason we say that the costs are duplicative and shouldn't be recoverable in those amounts, the first point, of course, to bear in mind is that the reason the hearing was adjourned in the first place on the 1st of March was that the judge wasn't satisfied that the claimants had properly effected service. So that was something which was within the claimant's control, which has led to the adjournment in the first place. So that's the first point. The second point is we say that the costs incurred are wholly duplicative. And what I mean by that, as I said, is that the removal claim was exactly the same on the 1st of March as it was on the 15th of April. The narrow legal points to be addressed were the same. The issues that required the judge's determination were the same. The claimants had already instructed counsel by the 15th of April, who had previously prepared a skeleton argument and turned up to the 1st of March hearing fully ready to argue both the removal claim and the set-aside claim. And when the hearing was adjourned for reasons within the claimant's own control, there was no need in principle for the claimants to prepare anything new when they turned up to argue those same points again. And we say that the claimants shouldn't be able to recover counsel fees for, in effect, the same hearing twice. Of course, there's going to be some unavoidable additional costs, but those costs relate to the costs of actually attending the reconvened hearing. They're not costs of substantial additional work being carried out. And if I can make good both the points of the extraordinary disproportionality of these costs, if we look at them, first of all, in the Bill of Costs at page 11 and 12,
This is in the bill, Mr. Doherty.
yes. So at the bottom of page 11,
Sorry, just bear with me. Right.
the brief fee for the 1st of March hearing is at the bottom, and the dollar figure is in the central column, which is just under $47,000 for the 1st of March hearing, which is the short adjourned hearing.
Mm-hmm.
And over the page is for the 15th of April hearing. Again, it's the middle column just beside number 10 where it says counsel's brief fee. We've got just over $60,000 again for ostensibly the same issues, the hearing of precisely the same claim.
Right.
Where the work had been carried out previously, skeletons had been drafted a little over a month before. Sorry, excuse me. And that, of course, the grand total of 107,000, as I've said, as it compares with the total bill of cost, well, the total cost schedule that was filed for the first defendant in respect of this hearing was $88,000. Counsel's fees for that hearing on the 15th of April for the first defendant were $14,000. So I think that's some 13% of the total of counsel's fees being claimed in this bill of costs. And that's, we say, something which needs to be determined as being reasonable and proportionate, having regard to the fact that these are issues which, on the claimant's own submission, revolved around narrow points of law and involved no substantial disputes of fact. We say, when one just looks at it as an overall figure and asks the question, as you're required to, Registrar, is the amount claimed reasonable and proportionate to the issues in this claim? Quite plainly, it isn't, just when you look at the figures themselves. But when you then consider it in context of have the amounts been reasonably incurred, the answer must be no, because if the claimant's position was that these were simple disputes that fell to be determined by reference to limited factual evidence and narrow points of law, it's not reasonable or proportionate to spend over $100,000 on counsel for, as the judge put it, a short adjourned hearing and a one-day hearing, nor is it reasonable and proportionate for counsel to incur those fees twice dealing with the same issues. And if I can deal with the points my learned friend makes about this, he seeks to suggest that, well, actually, the nature of the hearings was substantially different. We say that's a piece of material revisionism, because it's not how the issues played out ahead of the 15th of April hearing. So the point I think that's taken is the claimants say the costs aren't duplicative because of developments between the 1st of March and the 15th of April led to there being significant additional cost. And he refers to there being an additional bundle of 1,200 odd pages at that hearing. There's an obvious reason that argument doesn't work. And if I can break it down, first of all, the size of the additional bundle is somewhat irrelevant anyway, because when one is considering the issue that was determined, i.e. the removal claim, I've already taken you, Registrar, to the documents which were relevant to the resolution of that portion of the claim, and that didn't change through the filing of this evidence. But also, just putting it in terms of how things unfolded prior to the 15th of April hearing. If we go to page 108, there's a quite helpful summary of the chronology. But this is, if you go to page 107, you can see that this is a summary of a submission that was made by the claimants in their cost submissions. And it's at on page 108, paragraph 5, subparagraph C. What's said is that the issue of controversy in respect of the set-aside Part 8 issue was whether there were substantial disputes of fact relevant to the question of whether the agreement should be set aside. Contrary to the rules, the defendants did not serve their evidence until the 11th of April 2024, during the Eid holiday and after service of the skeleton arguments. The defendants then produced a 1,200-page bundle with approximately 1,000 pages of new material. At that stage, it was not possible for the claimants to take instructions before Sunday, the 14th of April, 2024. So in other words, when one is looking at the brief fees, those brief fees were incurred prior to any of this arising. So the skeleton arguments had already been filed before the evidence was adduced. Presumably the brief fee had also been negotiated and agreed and incurred prior to any of that happening. So when we see there being an additional brief fee of $60,000, that was nothing to do with the further evidence that was filed, because the further evidence that was filed all came after the brief fee had already been agreed and the skeleton argument had already been filed. There is no element of additional cost related to counsel arising from that further evidence. And so we say that the submission that the nature of the hearings was very different is simply misconceived and it's revisionist. Moreover, we can see from the bill of costs itself how little additional work arose as a consequence of the filing of these documents. And if one looks at page 27,
Right.
if we look at the bottom three entries of this page, you can see that on the 10th of April, there's reference to reviewing, on the 9th of April, you can see there's an email to the Claimants Council in relation to skeleton arguments, reviewing draft skeleton arguments, and so on. So the claimant's work preparing its skeleton and preparing for the hearing is being carried out at that point. And then it's at the bottom two entries of this page that one sees reference to the receipt of case bundle from defendants and review of the same. And then the 12th of April below that, reviewing defendant's case bundle, considering witness statement and new factual allegations made. Those are two entries which occupy a little under 7 hours of time. So in the context of the 107,000 being claimed across both hearings for counsel's fees, we say it's not realistically arguable that there hasn't been some duplication there. It may well be that there are elements of cost associated with reconvening an adjourned hearing, but as we put it, those costs would normally be expected to be limited to, in effect, a refresher fee. So a fee for attendance and arguing the points that you'd already prepared to argue at a prior date. But the incurring of those fees twice is unreasonable and it is disproportionate, and it shouldn't be allowed on that basis.
Just briefly, Registrar, by way of reply, if I may. First of all, the first point made by Mr. Doherty was that you should take into account the fact that the hearing, in his submission, the hearing was adjourned because of failure to effect service. And he said that was something within the claimant's control. That is not something that's relevant to reasonableness and proportionality. That's something that would have been relevant to the incidence of costs, but the judge has already dealt with that. So in my submission, it's not open to Mr. Doherty to make that point in the context of reasonableness and proportionality. The second point I make by way of response is that Mr. Doherty accepted in his submissions that there are going to be some unavoidable costs which are incurred where there is an adjournment. The difficulty with that is that if you look at what the first defendant is saying should be allowed under this, all they're saying should be allowed is a refresher fee for counsel. So that doesn't take into account preparation and attendance for the solicitors. So that what the first defendant is actually seeking is inconsistent with the acknowledgement that there will be some unavoidable costs, because that point must apply equally to solicitors as it does to counsel. The third point I want to make relates to counsel's brief fee, and Mr. Doherty described it as revisionist in response to my submission that the nature of the two hearings was different. I've taken instructions from my solicitors on when counsel's brief fee for the 15th of April hearing was agreed, and I understand it was agreed on the 11th of April 2024. So that's the same day as the first defendant served the witness statement and additional documents. So it's not correct to say that counsel's brief fee had already been agreed and then the additional documents were served and the brief fee didn't change. It was agreed on the same day. And more broadly, in terms of the nature of the hearings, this is the fourth point. The nature of the hearings is different, not just because of the additional documents served. As I mentioned in my opening submissions on this point, the nature of the hearings was different because, in part, because legal representation had been obtained by the defendants for the purposes or prior to the 15th of April hearing. And they've made clear in their acknowledgement of service that they intended to contest the use of the Part 8 procedure. So the issues did change between the two hearings, and it's not just a case of additional documents being filed, although that is part of the picture. And the final point relates to the actual quantum of counsel's brief fees. Registrar, as you can see, this point of dispute is limited to the point on duplication. There is a separate point of dispute, which is point 5, which you can see at page 54 of the bundle. And that relates to the actual amounts charged for counsel's brief fees. So I think some of Mr. Doherty's submissions were directed towards the amount as well. I wasn't proposing to address you on that yet because I think we're coming to it under point 5, but I'm in your hands as to whether you want me to do so.
Go ahead, Mr. Jackson.
Yes, so in relation to point 5, there are 2 points. There are 2 points made under the heading point 5, as you can see from page 54 of the bundle. The first is that counsel's brief fees should be disallowed completely for the 1st of March hearing and reduced to 33% for the 15th of April hearing. And the second is that counsel's brief fees for the 1st of March and 15th of April hearing are excessive. Now, the first point, again, I say is an impermissible attempt to rewrite the cost order made by the judge. And I don't propose to address you on that further. But on the second point, the actual amount of counsel's brief fees, my submission is that they are reasonable. And there are 4 points I make in relation to that. The first is one I've already touched on before, that it's worth bearing in mind the nature of the Part 8 proceedings. It's fair to say that Part 8 proceedings are usually straightforward and involve purely legal issues. But in this case, the Part 8 proceedings were hotly contested by both parties, both in terms of whether the claims should proceed under Part 8 at all, and in terms of the merits of the claims. And in relation to the set-aside claim, the court decided that that was too factually complex to proceed under the Part 8 procedure. So it would be wrong in my submission to think that these proceedings were a typical Part 8 procedure. They were more complex than that. The second point is that the submissions I've just made are reflected in the judgment that the judge gave in the Part 8 proceedings. As you've seen, it's a fairly extensive judgment running 30 pages, and it deals with a number of arguments advanced by the first defendant, challenging the use of the Part 8 procedure and also making points on the merits. And that's reflected also in the fact that, as I mentioned earlier, the 15th of April hearing took over a day of court time to conclude. The third point is that given those points of context and the nature of the proceedings, it was reasonable to instruct leading counsel. No junior counsel was instructed at this stage in the proceedings, namely the Part 8 phase. Only leading counsel was instructed, and that was entirely reasonable given the complexity. The fourth point, as to the level of the brief fees specifically, is that those reflect the market rate for leading counsel in the DIFC. Now, it may be that lawyers could be paid less, but if that's what the market demands, then in my submission, that is a fair assessment of what is reasonable. So those are the points I want to make specifically on counsel's brief fees in the amount, unless I can assist you any further, Registrar.
Thank you.
Would it assist if I address you on those points in relation to point
Yes,
5?
very
It does
briefly, please,
seem
Mr.
there's
Doctor.
some logical sense in taking it together. Just a few points, because I covered some of them already, but one is considering questions of reasonableness. Of course, the relevant consideration is one which has to have regard to the nature of the proceedings. It was the claimant's decision to proceed with this matter as a Part 8 on their own assessment that there were no substantial disputes of fact, and what the court and what the registrar you're being tasked with is to determine what are reasonable and proportionate costs of a one-day Part 8 claim. And one has to, in that context, view questions of reasonableness and proportionality by reference to what a Part 8 claim is supposed to be, which is relatively limited disputes of fact, turning on narrow points of law. And that is precisely what the claimants told the judge was an issue in the proceedings. And its costs that it incurred should have been proportionate to those issues. The point that was taken that one can see there being higher costs on the 15th of April, I think it's now suggested that it might be because there was opposing counsel on the other side. I'm not aware of that point being made previously, but of course that obviously cuts both ways, because there are two hearings here where we're considering the costs of together, and that point cuts both ways, because if what's being said is that it was reasonable and proportionate to spend $60,000 instructing counsel to attend the reconvened hearing on the basis that there was opposing counsel on the other side, notwithstanding the opposing counsel's costs were some 13% of the overall counsel costs charged by the claimants. One then also has to ask, well, for a short hearing that ended up being adjourned against a litigant in person on the 1st of March, were the costs incurred of that of over $45,000 reasonable and proportionate? So that, if that's a point that has any weight at all, it has to cut both ways. Because if it's proportionate in respect of the second hearing, it shows somewhat the disproportionality when it comes to the first hearing, in which Mr. Shehata represented himself. But we also, of course, when it comes to counsel's costs, have assistance from is the overall reflections that I brought you to that Justice Lemire made when he handed down his costs order, which is the remarks that the costs incurred overall, in the sum of over $260,000, was substantial for a short adjourned hearing and a one-day Part 8. Counsel's fees represent some 40% of the total amount being claimed. So we're talking about a pretty substantial proportion of what is already a pretty substantial amount. And in considering questions of costs, Registrar, you're obviously required both to look at these costs on a line-by-line basis, but also have regard to the overriding objective, which requires proportionality, and that's expressly stated in the court's rules. But it's not difficult to step back and look at the competing cost schedules filed and the competing counsel's fees in addressing these issues, and see that the overall sum of $107,000 on any analysis is excessive, it is not proportionate, and it is not reasonable. And it's when you then feed into that the context of the procedural history of the case, which is that the reason for the adjournment, as I said, has to do with service issues. It's not to do with a changing nature of the substantive issues in the case or the points that ultimately need to be argued at trial. I mean, I take my friend makes the point that council's brief fee was agreed on the 11th. There's no substantiation to that. There's no evidence which shows when the brief fee was proposed, for example, because it might well be that it was accepted on the 11th, but it might have been proposed prior to that. But without substantiation and without documentary evidence, registrar, you can't take points being put on instruction at face value in that way. And on a standard assessment where there are issues of doubt, those are to be resolved in the first defendant's favour in this case. This is not an indemnity cost assessment. And on that basis, I mean, there are obviously a number of ways that registrar are able to approach this. The primary basis on which we put it is that the cost of the first hearing shouldn't be recoverable due to the nature of the adjournment. But even if one is wrong about that, one has to look at it from a general standpoint of reasonableness and proportionality. We say that if the costs incurred in respect of the first hearing are the $49,000 for preparing the skeleton at that point in time, that would reflect almost all of the work that needed to be done for the second hearing in any event, that there is duplication, that even taken in isolation, the cost of the first hearing are high, and we would, in a normal assessment, be asking for that sum to be reduced. But the cost of the second hearing would then need to be substantially reduced to reflect the substantial duplication of work involved. Because if any of the costs of the first hearing are going to be allowed, it would be on the basis that the work had already been done, had already been prepared, and did not need to be, there didn't need to be any reinventing of the wheel for the hearing on the 15th of April to get there.
So we've combined points 3 and 5, I would say, to an extent. My directions would be that the costs of the first hearing are recoverable. I do want to discuss the figures, though, at some point. I do believe that they are somewhat excessive, and we can go through that at a later stage. The remaining points surrounding duplication, there are again further amounts that do need to be reduced. I would not say that the council's fees would have that would have incurred for the 15th of April 2024 hearing should have been a refresher fee. I think the nature of the hearing significantly changed, and therefore I would allow some of council's fees, ultimately not all. And there is going to be a reduction, obviously not in the amount that the first defendant has suggested, but there will be a reduction to some of the fees that were incurred just on the basis of reasonableness and proportionality. Unless there's anything I've missed, please let me know.
From our perspective, I don't think there's anything you've missed, Registrar. In terms of so as I understand it, there are two aspects in which you consider that the fees should be reduced, and they're both relating to the brief fee for council's fees for the two hearings. The question then is, how much should they come down by, and what would be reasonable and proportionate?
Right.
In
Just
terms
want to
of
turn to the bill very quickly, because I think we can take care of this together.
yes, the first brief fee is at page 11 of the bundle.
Page 11. And this is at the very bottom. It's about 47,900 and sorry.
Correct.
This
Yes.
is the figure that we're looking about, and that's 35,000 British pounds.
Correct. So it's been converted. And in terms of the figure, Registrar, I think it's for Mr. Doherty to say what figure he suggests it should be reduced to, given that it's a point of dispute that his client has raised. It hasn't been something that's been mentioned, as far as I can see, in the points of dispute so far.
Doherty, would you like to proceed with that suggestion?
Yes, well, I mean, I think the starting point, usually in these sorts of cases, has to have regard to the fees incurred on the other side. As the judge said, in respect to the 15th of April hearing, it was a case in which there was mixed success, and that reflects the order that he made. In circumstances where there was mixed success, one can compare the figure of 60,000 for the second hearing with the figure of $14,000, reflecting counsel's fees in that case. And I think that in our points of dispute, what we had suggested was limitation of the recoverable fees for the hearings to be $20,000.
$20,000 for
Yes.
both hearings.
That's for the second hearing. I think that was on the premise that
For the
the
second
hearing
hearing.
cost for the first hearing would be disallowed, having regard to the adjournment. But in respect of the first hearing, the appropriate standpoint, as my learned friend had said, is that if the nature of the hearing changes because there's opposing counsel, the first hearing needs to have regard to the fact that it was a short adjourned hearing against the litigant in person.
If I may just respond to that briefly, Registrar. In terms of the first here, I'm not clear what figure is being proposed for that. If there's to be a reduction, I don't accept that it should be to the level of junior counsel on the other side. Now, it would, as I submitted earlier, it was reasonable to instruct leading counsel. Leading counsel inevitably charge more than junior counsel. And while I, of course, acknowledge you have ruled, Registrar, that counsel's fees should be reduced, reducing them to the level of junior counsel's fees is, in my submission, excessive. So what I invite you to do is to fix a midpoint between what junior counsel would charge and what leading counsel would charge. In relation to the second hearing, it was said that junior counsel was charging $20,000 US dollars, as I understood it from Mr. Doherty.
14.
14.
Yeah, I can find you the page reference for the cost schedule. There's a dirham figure in the cost schedule that was filed for that hearing.
It's 30. I saw it somewhere. It must have been 32,000, if I'm not mistaken.
Yes.
Somewhere in that range.
Yes.
Okay.
Yes. There's the statement of costs right at the end, at page 115 of the bundle, but I can't see that contains the exact. Well, yes, it may be 13 there. But I mean, it doesn't affect the general point I was going to make, which is that what's being suggested then is that counsel's brief fee should essentially be chopped into less than 1/3. And that, in my submission, is too much, given that it was appropriate to instruct leading counsel. There should be some allowance for the fact that leading counsel will charge more than junior counsel. So, I mean, in relation to counsel's brief fee for the second hearing, what I'd invite you to award is $40,000 US dollars, which is a midpoint in between what junior counsel, or roughly a midpoint between junior counsel's fees and the fees that have been claimed in the bill of costs. In relation to the first hearing, I'm not clear on what's being proposed for that. But if one applies the same reduction of allowing, let's say, 2/3, by my maths, that would come to something around $30,000 US dollars.
Right, I'm going to fix the first brief fee at an amount of 38,000. And that's a slight, almost 20% reduction. So that's $38,000 for the first brief fee.
I'm grateful.
Moving on to the second brief fee, I'm going to adopt the same approach. And that's, so we're looking at a figure of, if I'm not mistaken, slightly above $60,000.
Yes.
To be exact, it's 60,318. That's about. So another slight reduction in about 20% will take us to about 48,500 US dollars. And that's what I propose to fix the second brief fee at.
Thank you, Registrar. I think that deals with points 3 and 5. Hopefully we can speed up as we go along. The points of dispute do get more limited as we move towards the end. If I can deal with point 4, and I will keep my submissions as brief as I can in relation to this. At point 4, you can see at page 53 of the bundle. And this, Mr. Doherty's clarified in his skeleton argument, which I don't need to take you to, I think. This point of dispute relates specifically to the 1st of March hearing. And the first defendant's complaint, in short, is that both partner and associate attended the hearing and participated in a catch-up call. And the first defendant says only an associate should have done that. We say this point should be rejected. And there are 2 reasons that I advance in relation to that. The first is that if one looks at the actual amount that's incurred for preparing and attending the hearing and participating in the catch-up call, it's relatively modest by the standards of commercial litigation. It totals 13,000 US dollars. So not nothing, but not the biggest sum imaginable. The second point is a more fundamental one, which is that in my submission, it was entirely reasonable for both the partner and associate to attend the hearing and the catch-up call. And I'll take those in turn. In terms of the hearing, the way it's described in this point 4 is that it was unopposed and short. Now, that's not entirely accurate. The hearing was opposed by the first defendant, albeit that he was acting as a litigant in person. He turned up to the hearing and he sought an adjournment on the basis that he needed time to instruct lawyers, and that adjournment was granted by the court. So it's not correct to say it was unopposed. And moreover, if the adjournment had not been granted, the hearing would have involved a trial of the Part 8 claims, because that's how a Part 8 procedure works. So this is not an interim hearing dealing with an interim application. It was a final hearing, or intended to be a final hearing prior to the adjournment, which was of significant importance because it would determine whether the claimants were entitled to the substantive relief that they were seeking. In terms of the client call, in my submission, it was reasonable to have both fee earners on the call. It was a catch-up call following the hearing. And as I say, this was an important hearing. So it was reasonable to have both fee earners on the call to relay to the client the outcome of the hearing and discuss it with them. And moreover, it's likely to have been more efficient to do it that way. The delegation of work between a partner and a junior associate is usually that the partner will be supervising, taking instructions, giving advice to the client, giving instructions to counsel, and the junior associate will be doing a lot of the legwork. Now, it's more efficient to have both of those people on the client call, the partner so that they can advise the client and take instructions, and the associate so that they're aware of what the next steps in terms of the legwork need to be. And one can test it by imagining what would happen if one of them didn't attend the call. What would need to happen in that scenario is that the partner would need to update the associate, or the other way around. So the idea that you shouldn't have both on the call is more inefficient. So those are the points that I make in relation to point 4, Registrar.
Right, Mr. Doherty.
Yes, thank you. The points that were made by my learned friend already about it being reasonable to instruct leading counsel in a case like this is a factor which needs to be taken into consideration in how you manage the rest of the case. And one has to take that broader view of proportionality and reasonableness. The first about hearing was a hearing that was being attended by the first defendant as a litigant in person. It's our position that in those circumstances, it was obviously reasonable and proportionate to have a limit of one additional fee earner together with leading counsel actually attending the hearing. To the extent that it's alleged that there needs to be someone with the ability to make decisions, it may well be that that person should be the partner, but if that's the case, there's no reason to have an associate in addition to both the partner and leading counsel in attendance at a hearing. It is, of course, up to any party in litigation how they choose to resource their cases. So if it was found to be convenient to have another fee earner on it because that's what the client wanted, that's one thing. But that's not a proper answer to this point of dispute, because both parties, including the first defendant when it comes to attendance at its own hearings, both parties need to show that their own costs are reasonable and proportionate. And just because you want multiple fee earners at a hearing does not entitle you in the context of every hearing to actually recover those amounts on a standard assessment. And so on that basis, that where one has a hearing, where one has instructed leading counsel in a hearing, and where one has a partner in attendance, the people who need to attend both the hearing and the call to inform the client of what happened afterwards would be limited to those individuals. You do not need additional fee earners involved in that process. That's not reasonable or proportionate.
All right, Mr. Jackson, anything to say in response briefly?
Nothing by way of response, Registrar.
Would you mind taking me to that specific point in the bill?
Yes, it's at page 11 of the bundle it starts.
Page 11 of the bundle?
Yes. And it's 2 items. It's item 7, which you can see on page 11, which is the preparation and attendance at the hearing of the case. And then over on page 12, actually, I think that's been... I think it may just be item 7 then.
It's item 7. Are we looking at this figure of about roughly $21,000?
So it's...
Or is that?
The way, so if you look at where item 7 appears in the very first column on page 11, and you track across the right hand side, it comes to around $4,200 US. That's the preparation for an attendance at the hearing. There is also a catch-up call on the next page, which falls under item 9. But as I understand it from Mr. Doherty's skeleton, this point of dispute is just limited to the 1st of March hearing, and the catch-up call actually relates to the 15th of April hearing. So it may be that it's just limited to item 7.
So what is the figure? What just so I understand what I'm looking at. The
Yes.
figure right next to it. So the figure right next to the 4,200 figure, which seems to be about 21,000. What does that figure relate to? Is it all of the 1st of March accruals, I would say?
21,000 registrar. I don't see that myself.
It's right on to the column on the right of, so we're still at item 7. It says 20938.
Ah, yes. So that is VAT. So that's VAT. That's $209
Okay.
and 38 cents.
Mm-hmm.
So that is the VAT.
So
and
of the $4,200 figure, 209 of that is VAT, I'm assuming.
Yes. So if you look at the headings at the column at the top, so this is the VAT column, and then the final column on the right hand side is the total.
Okay.
And I think that includes the VAT figure that we just looked at. Yes.
I mean, it's perfectly reasonable to me to have a partner attend and as well as a junior. I don't think that's something unusual in my experience. I would apply a slight reduction to this amount. I'll just sort out the figure very quickly.
I should just correct one thing, Registrar, which I think actually the VAT gets added on right at the end of the bill. So the 4,187.50 figure doesn't include VAT, I think.
So unless I misunderstood what you've just said to me, the VAT figure is going to be added on to the total figure. So I would suggest we just add it on to whatever the total will be. So I'm not going to look at that figure right now.
Yes.
I think that would be sense. I'm going to bring down this figure by 10% to about $3,800.
Thank you, Registrar. I think that deals with point 4 then, and we dealt with point 5 earlier, so we're now on to point 6. Point 6, you can see.
Sorry, Mr. Jackson, sorry to interrupt you. I've just been timed out of the bundle. Would you mind giving me the bundle reference to point 6 again?
To point 6 is at page 55 of the bundle.
Right.
So we're back in the reply to the points of dispute.
Mm-hmm.
And again, I'll try and deal with this very briefly. A lot of what's said in this point of dispute, again, is seeking to circumvent the costs order. So that the first sentence, many attendances on the client cannot be attributed to the successful application. That is not open to the first defendant to say in light of the costs order. The same goes for subparagraph 2, where it said any attendances in respect to the witness statement should be 1/3 recoverable, because what's being said there is only the part relating to the removal claim should be recoverable. And then finally, in relation to point 3, again, where they say the matters in relation to IP ownership not recoverable, that's relating to the set-aside claim, and it's not open to the first defendant to take that point. So there are only 2 complaints which go to reasonableness and proportionality. The first is in subparagraph 1, where they say 17 hours of attendance on the client by 2 different fee earners is excessive. The majority were incurred by a partner. And there's also a point relating to service of proceedings at subparagraph 4, which I'll deal with in a moment. But if I can deal with the 17 hours first, we say that complaint is wrong. And the reason we say that is that it's important to put the 17 hours into context. The Part 8 proceedings ran between May 2023 and April 2024. So that's a period of approximately 11 months. And during that time, there was significant work to be completed. The work that is included within the attendances of 17 hours includes the review of documents, preparation and drafting of a witness statement, preparation and drafting of the claim form, which included particulars of claim, as well as emails and calls with the client to take instructions and give advice. In those circumstances, and given that it relates to such a substantial period of time, my submission is that 17 hours is entirely reasonable. Indeed, it's surprising that more time wasn't incurred during that period. As to the service point, under the costs order, as you've seen, the judge determined that the claimants were not entitled to recover the two costs of alternative service applications they made. Those were made on the 25th of October 2023 and the 1st of November 2023. And we accept that we're not entitled to the cost of those applications. That's what the judge ruled. But the first defendant's complaint on the service point is much broader. Essentially, every time the word service is mentioned in the bill of costs, the first defendant has said, well, that relates to alternative service, and therefore you're not entitled to recover it. And that's just not right. It's obviously a flawed approach. And just to give a few examples of that, our alternative service application failed, but what that meant is we then had to serve in Egypt. We had to serve upon the first defendant in Egypt in accordance with local Egyptian law. And for that purpose, it was necessary to instruct Egyptian lawyers to effect service and to advise on service. So there are costs relating to service in Egypt, which we are entitled to and have claimed, and which do not relate to the alternative service applications, which had failed by that time. Similarly, there are costs relating to providing general advice to the claimants on service, which don't relate to the alternative service applications themselves. They don't relate to the preparation and filing of the applications. And again, we're entitled to and have claimed those costs. And just to show you one example or a couple of examples of that, if you would look at page 14 of the bundle registrar, in the middle of the page there in the bill of cost, you'll see that on the 13th of December 2023, there is an email to Thamer, that's the first claimant, re-service of documents. And then over the page, page 15, towards the bottom of the page, 9th of November 2023, email to Thamer, re-service of proceedings in Egypt. And then at 20th of November, email to Thamer, re-service of proceedings under DIFC rules, and it goes on. Now, those are costs relating to the service of proceedings in Egypt, not the alternative service applications. And just because the word service is mentioned, that doesn't mean we're not entitled to recover them. Those are my submissions on point 6.
Mr. Doherty?
Yes, Registrar. I was going to suggest that I give you my, because they deal with common issues and common heads, of course, I was inclined to give you my submissions on both point 6 and point 9 together, because they relate to attendances and work on documents. If you have no objections to that, obviously you'll need to hear from Mr. Jackson.
No objections, yeah. We will need to hear from you, Mr. Jackson, eventually on those points.
So point 6 relates to excessive attendances on the client. Point 9 relates to excessive work on documents in the bill of costs. And as I say, those raise common issues. The first broader point we make relates to your determination of whether specific items of cost were reasonably and proportionately incurred, having regard to the context of the proceedings. And I made the point earlier that whether one, how one frames the distinction between the removal claim and the set-aside claim in some senses doesn't actually matter, because the question of reasonableness and proportionality still requires one to look at what time costs were incurred. Having regard to what the issues were in the Part A claim, one has to then determine whether the overall amount of time spent on those issues was actually reasonable, proportionate, and therefore recoverable, with the claimants bearing the burden of that. So the points in relation to issues affecting intellectual property rights, issues affecting service, all still apply. One still has to consider were those costs reasonably and proportionately incurred. But beyond that, one can still see within the bill of costs, when it comes to attendances and work on documents, there being portions of costs which have been incurred which don't relate to Part 8 proceedings, because the bill of costs says as much, or two, where they expressly fall outside the scope of what the judge said is recoverable, either due to the date on which they were incurred, or because they relate to issues in which the judge expressly said you were not allowed to recover. And what I propose to do is to take you through those specific items. So if I can start with page 14.
Right.
These are, first of all, what we say are excessive items claimed in the bill of costs, which relate to questions concerning intellectual property ownership of Medica Cloud Care. You've already had my submissions on that not actually being a part of the Part 8 proceedings, but even in isolation, one can see the excessive amount of work and the overall scope of work done spent on these issues. So at 14, for example, in the middle of the page on the 8th of September, there's reference to time incurred on IP ownership when it comes to attendances on the client, which are repeated over the page on 15, on the 11th of September, third line down.
Mm-hmm.
And again, in the middle of this page, after it says 5 long emails on the 7th of September, there's another line item on this issue. And at page 17, when it comes to attendances on counsel, for example, there's another long email on this issue on the 14th of September, 2023. We see our multiple long attendances dealing with IP issues, which are replicated in greater extent at Schedule 1 to the Bill of Costs at page 21 onwards. I'll take you through those. So on the 28th of March, the third entry down is an hour and a quarter dealing with White and Case Hamburg in relation to IP registration. On the 31st of March, 2 hours and 12, reviewing documents including copyright registrations. At the bottom of that page on the 12th of April, over an hour, and the entry continues into page 22, but it talks about an email to Galadari re-IP registration. And then there are a whole sequence of these on page 22. So providing advice on the legal relevance of copyright, and just under an hour. 26th of April, reviewing email from Galadari on registration of IP rights. 5th of June, email to the White and Case IP team Again, on the 5th of June, IP analysis. 6th of June, overview of medical cloud care software based on international IP treaties. 12th of June, a call re-IP infringement proceedings. So there are a multitude of what we say are excessive attendances on this issue, which ultimately we say had no bearing anyway on the Part 8 issue. But we also see, whilst we're on the work on documents, is categories of work which plainly cannot be recovered in the context of a Part 8 claim. So, for example, on the 17th of July 2023 and on the 18th of July 2023, there's specific reference to drafting particulars of claim for Part 7 DIFC court proceedings. Now, Part 8 proceedings, you do not draft the particulars of claim, and when this claim was filed, there was no particulars of claim for Part 8 proceedings. So it's unexplained and unclear why those items are sought to be recovered in the context of the judge's order in this case, which is an order in respect of the cost of Part 8 proceedings. And there are further items dealing with that at page 23, on the 27th of July, and on the 14th of August. There's updating particulars of claim and reviewing and amending draft particulars of claim. On the 1st of September, there's an email being sent on the strategy for Part 7 proceedings. And then on the 4th of September, there's considering requirement for particulars of claim. Again, that would be in the context of Part 7 proceedings where you drafted particulars of claim. And then 4th of September, preparing details of claim to be included in Part 7 proceedings claim form. And then, if I can complete this run on page 24, we have a reversion to further issues dealing with IP rights. So 11th of September 23, there are 2 entries reviewing inter-OCO registration and reviewing email from the first claimant on ownership of IP rights. So the point we make about these entries is that there are these huge swathes of time and cost in these proceedings relating to IP issues, which are disproportionate in the context of the Part 8 claim. They are likely, we say, more appropriately characterized as Part 7 cost, but in any event, it's excessive given the scope of the issues that were in dispute. And so we say that where excessive time has been spent dealing with these IP issues, they would need to be reduced. Similarly, there are express costs which are said to have been incurred pursuant to filing of a Part 7 claim. So that's work drafting of particulars of claim and a Part 7 claim form, which is not work product, which has had any bearing on the Part 8 proceedings, because the Part 8 proceedings do not have a particulars of claim. There's now particulars of claim for the remnant of proceedings that are going to trial under Part 7, but we say that those costs plainly cannot be recoverable costs of the Part 8 proceedings and should be disallowed entirely. There are other issues, we say, which are not costs of the Part 8 proceedings. For example, at page 28, apologies, at page 27, on the 1st of March 2024, there are costs associated with the joinder of Health Insights Malaysia. We say those aren't costs of the Part 8 proceedings because Health Insights Malaysia is not the subject matter of any of the orders made in the Part 8 proceedings, and their continued involvement is only ever going to be dealt with from a cost perspective in the Part 7 proceedings. So again, that's a category which should be disallowed. And these aren't insubstantial amounts. If you add those items together, it's around 25.5 hours of mid-level and senior associate time. It's 4 hours for another senior associate, 4.25 hours of partner time. So we're looking at in the region of around 21 to 22,000 in respect of these categories of costs. And we say that having regard to the issues in the case, those costs are not reasonable and they're not proportionate with respect to these Part 8 proceedings. That's the first broader point. The second relates to costs arising from service issues, which we say two things about. One is that some of those costs are on their face simply not allowable at all. And two, that in any event, a lot of the costs incurred are not reasonable or proportionate, particularly having regard to the circumstances of this case. As I say, where the judge determined that he was not satisfied that service had in fact taken place. And so the reasonableness and proportionality of those costs should bear that in mind. Dealing with the two aspects, if we go to page 25, on the 20th of October 2023, in the middle of the page, there's reference to filing application notice for alternative service, which of course is a category of cost that the judge said was not permissible and was not recoverable. And that's 2 hours. And at page 24, we have another run between the 18th and 19th of September, which also are costs incurred in relation to the alternative service applications. So on the 18th of September, there's reviewing an email from leading counsel on service, 1 hour 42. That then leads to a discussion on the 19th of September for 48 minutes on alternative service of proceedings. And then another 2 hours on the 19th of September, which says reviewing email, reapplication for alternative service, discussion with Ms. Roshan of the same, reviewing the rules of court in connection with the same. So all of those costs have to be disallowed in their entirety. The judge has said that those cannot be recovered. But it's not only those items, it's items in relation to service in general, we say are excessive in the context of the case. So on page 25, from the 22nd of November in the bottom half of this page, there are a series of costs incurred in connection with service. So considering an update in discussions with the Egyptian lawyer on the 22nd, an email updating on discussion with Egyptian lawyers. 28th also is translation of claim form. 11th of December, at the bottom of this page, is an email in relation to service of proceedings, taking 1.25 hours. 4th of January, over the page, on page 26, 1.75 hours reviewing notice of service. Another 3/4 hour below that on the 8th, discussing notice of service. Another half an hour on the 15th of January, considering the rules of court on service. 15th of January, following up with local counsel on dispute notice. Another hour and a half on the 15th of January, discussion, reservice of proceedings. 16th of January, email, reservice of notice of dispute. 18th of January, emails on service. 19th of January, conferring on service of dispute notice. 22nd of January, reviewing translation of proof of service documents, sending comments on the same. So these costs in themselves, we say, are substantial and involve disproportionate amounts of time. As I say, particularly in a context where the judge was not satisfied that any of that work was fruitful. And the costs associated with that, again, are not trivial. So it's around $1,250 when it comes to partner time. It's around $5,000 of associated time. We say that that needs to be substantially discounted. The costs of alternative service issues must be zero. And then, of course, the broader point with all of this is excessive expenditure of time in general, which links back to point 2, which is one always with cases like this has to take a broader view of the complexity of the proceedings, the issues involved, and to look at the overall bill of costs and decide, is the amount of time being spent on attendances and is the amount of time being spent on documents reasonable and proportionate to the issues? And where the answer to that comes out of a bill of costs for a one-day hearing and a short adjourned hearing at $270,000, clearly that has not been a proportionate or reasonable use of time and cost. I also remind you, Registrar, of the standard that applies and the assumptions that apply on a standard assessment, which is ultimately it's for the receiving party to persuade you that the cost it is claiming have been reasonably incurred and are proportionate. And if there is any doubt about that, the doubt has to be resolved in the paying party's favour. So that's the first defendant's favour.
Registrar, if I can briefly make some points in response. I'm going to focus on point 9 because that was the point I hadn't addressed you on before. The first point I want to make relates to Mr. Doherty's submissions on the IP ownership issue and the joinder of the Malaysian entity. And his submission was that those are issues which, as I understood it, his submission was that those are issues which don't fall within the Part 8 phase. Again, that is an attempt to circumvent the judge's cost order. The work was done during the Part 8 phase up until the 15th of April 2024. And the only question that needs to be considered on detailed assessment is, are the sums reasonable and proportionate? It is not open to the first defendant, and the point keeps being made. It is not open to the first defendant to say, well, that's not included within the scope of what the cost order refers to. So I say that point goes nowhere. The second point relates to the work that Mr. Doherty says was done on Part 7 proceedings. And he made the point that there are no particulars of claim for the Part 8 proceedings. That is not correct. And if I could take you to the particulars of claim, as I mentioned in my opening submissions, they're contained within the claim form, but they are nonetheless particulars of claim. It's at page 2 of the bundle, Registrar.
Right.
And you'll see there at the top of the page, very top, it says type of claim P8, Part 8. And then there are particulars of claim set out on pages 2, 3, and 4. So there are particulars of claim. They're just contained within the claim form. And obviously that is an option when filing the claim form, that you can include them within the claim form or attach them separately. And if you go back to page 1, you'll see that the issue date is the 23rd of October 2023. And that is the issue date of the original Part 8 claim. So the work that Mr. Doherty was referring to in terms of drafting particulars of claim does relate to the Part 8 claim. It doesn't relate to the Part 7 proceedings, and it's therefore recoverable. Now, he took you to the bill of costs and to a couple of entries which refer to Part 7 rather than Part 8. I've taken instructions from my solicitors, and I understand that to be an error because there was, if one looks at the timing of those, they're before the commencement of the Part 8 proceedings. So what the work actually relates to is the drafting of the particulars that we've just looked at. It would have been quite odd in my submission to draft Part 7 particulars of claim where you're looking imminently to start Part 8 proceedings. That just isn't realistic. So I submit that all of that time relating to the particulars is recoverable because it relates to Part 8. The third point I want to address relates to service. Now, Ms. Doherty took you to a couple of line entries which do specifically reference alternative service. If we could just look at them. So first at page 24 of the bundle. And he referred you to the line items on 19th of September. So the discussion, re-alternative service of proceedings, reviewing email from T. Montague Smith, re-application for alternative service. And then also over the page at page 25, he referred you to the line item on the 20th of October 2023, the filing application notice for alternative service. Now, in relation to those three line items, I do accept, and I was going to come on to this, I do accept that those should be stripped out of the bill of costs because those appear on their face to relate to the applications for alternative service. So I accept that the court should take those out. What I don't accept, and in my submission it would be wrong to accept, is that the court should remove all of the line items, all of the other line items relating to service generally. And that appeared to be what was being suggested by Mr. Doherty, and it's the point that is certainly made in the points of dispute. As I submitted earlier, there are numerous line items which relate to service of the proceedings following the alternative service applications having failed, and they do not relate to the alternative service applications themselves. And Mr. Doherty took you through a few of them earlier, but if we just pick up some key examples, at page 25 of the bundle, you can see the line item which is on the first 8th of December 2023 line item, attend to email from K.L. Lethi, re-service of proceedings in Egypt. That is not alternative service because the application for alternative service was to serve by email. It wasn't to serve physically in Egypt. So that is not something that should be stripped out. And likewise, the same point goes for 11th of December, and it follows on from there. And if one looks at page 27, just to give a few other short examples, you will see at page 27, Registrar, that on the 28th of Feb 2024, at the very top, there is filing certificate of service. So that is a certificate certifying that service has been effected in Egypt, not by email, so it's not related to alternative service application. And again, on the second line item, 1st of March 2024, again, correspondence, re-service of process in Egypt, and it goes on. So one can't simply say, well, the judge said you're not entitled to alternative service, so you're not entitled to any service, any cost relating to service at all. That is fundamentally wrong. The final point on this is in relation to the actual reduction that's being proposed. Ms. Doherty's submission was that our costs are unreasonable, disproportionate, but there isn't actually a proposal as to what you should reduce them to. So in my submission, the appropriate course for the court to adopt is to remove those three line items that I showed you relating to alternative service and allow the remainder. Unless I can assist any further, Registrar, those are my submissions on those.
Mr. Jackson, could you take me once again through the IP issues?
Yes.
Yes.
Yes. So the IP issue relates to the set-aside claim, because the set-aside claim is a claim to set aside an agreement whereby IP was transferred by the second defendant to the third defendant. So that is the nature of the set-aside claim, and that's where the IP question comes into. Now, the reason why that doesn't matter for the purposes of the detailed assessment is because the set-aside claim formed part of the Part 8 phase. It's going to continue in the Part 7 phase, but it formed part of the Part 8 phase as well. And that's the part of the judge's costs order that I took you to earlier, Registrar, where he talks about the Part 8 phase being a distinct phase of the proceedings that is concluded, and including both the removal claim and the set-aside claim. So we are entitled to recover 50% of the costs of the set-aside claim up until the 15th of April 2024. And those costs include the IP issue. I hope that assists, Registrar. That's all I was minded to say on that.
Right. I think in the interest of time, I'm going to leave the parties to sort out the arithmetics on this, given it's going to relate to entries. So I'm going to disallow or remove the 3 entries related to alternative service, while allowing the remaining entries relating to service, although at a reduction. I'm going to allow the entries on particulars of claim, although I'm going to reduce them. Right, and I'm going to allow a portion of the IP-related issues, or the IP-related entries. Okay, I think that sorts it out. In terms of a reduction, I'm going to direct for a 30% reduction on all of these entries.
Registrar, could I check, was that 30%, 30?
30, yes.
Thank you. Yes, I'm sure we can work out the sums on that. And we'll obviously have to file an updated bill of costs for your approval in any event. All right, we're then on to, so we dealt with points 6 and 9. We are then on to point 7. So point 7, you can see, Registrar, at page 56 of the bundle. And again, in my submission, a lot of this point of dispute is just impermissible because it seeks to undermine the judge's cost order. So where it's said in the second sentence, some of the attendances are not recoverable because they're not in any way attributable to the successful application. Again, that's trying to draw a distinction between the removal claim and the set-aside claim, and that isn't open to the first defendant. Likewise, where they say attendances in respect to the witness statement should be a maximum of 1/3 recoverable, the same point applies. The part of the dispute relates to the service point that I've already dealt with, so it may not be necessary for us to go over that. The same points apply, that the relevant line items, and I'll show you them very briefly. It's page 17 of the bundle. And page 17, you can see in the middle of the page, there are 2 attendances by solicitors. The first is an email to T. Montague Smith, re-service of proceedings. That's 18th of January 2024, so well after the alternative service applications. And then on 4th of March 2024, email to T. Montague Smith, re-service of amended claim form. So those service points are entirely unrelated to the alternative service application. And given that you found, Registrar, that in relation to the earlier item, that general service items should be allowed subject to reasonableness and proportionality, I say that the same approach should apply here. Those should be allowed. There's no basis for excluding them in their entirety. Leaving aside those points on impermissibility in service, there are only 2 complaints that the first defendant makes in respect to this point of dispute. Firstly, it said that attendances relate to Part 7 proceedings, and secondly, that a partner and associate shouldn't both attend on leading counsel. Each of those points in my submission is wrong. The first point isn't really explained in the points of dispute. It's not clear what attendances are said to relate to Part 7. And when you look at the bill of costs, all of the attendances under this item relate to the Part 8 phase. So I'll just show you that briefly. If you go to page 16 of the bundle, so we're looking at item 12, which starts just under item 11. And you can see that the first item is 1st of September 2023. That's around a month before the Part 8 proceedings were commenced. And then if you go on to the next page, page 17, just above item 12, you can see the end of, sorry, just above where the number 12 appears. You can see the end of item 12. And the final line item is 4th of March 2024, email to T. Montague Smith. So that's all of that is within the Part 8 phase. It's prior to the 15th of April 2024. So none of it relates to Part 7 proceedings. So that point is, in my submission, just wrong. As to the second point, that both a partner and associate should attend on leading counsel, I repeat the points I made earlier, that it is reasonable for both a partner and an associate to attend on leading counsel. And in relation to the client call, you found, Registrar, that it was reasonable for both to attend that, and that was a client call with both the client and counsel. And on my submission, the same points apply here. Those are my submissions on point 7, Registrar.
Mr. Doherty?
Yes, I think I can deal with it relatively briefly, Registrar, because you have some of the submissions on points which are common already. The broader point, first of all, is that the overall sum of $5,400 is excessive for attendances on leading counsel, given the issues in this case. We say that there are inefficiencies built into that by the use of both excessive attendance by both fee earners at partner level, but also mid and senior associate level, which we say were unnecessary and not reasonable or proportionate for leading counsel, and that attendances should be restricted to one fee earner at associate level. Then the second point relates to some of the specific items, some of which we've already covered in the context of documents and where a similar rationale may apply. So that's attendances concerning views on IP registration. One might see a common approach being adopted. Similarly, attendances relating to Part 7 issues. So, for example, the references to attendances in relation to particulars of claim, and similarly references to attendances in connection with service of proceedings. We make all of the same points that we made on attendances on counsel that we did in respect of work done on documents.
Nothing in response from me, Registrar.
Could I be shown again the line item for the attendance on counsel? I think
Yes.
I have one at page 16. Is there another one?
It's page 16 through to 17.
Okay.
It finishes halfway down page 17, where you get the total amount.
Right. So for the first entry, and this is a partner entry, I believe. Ms. Rashan is
Yes.
a partner. Right. I'm going to reduce this entry to that of a senior associate level, and I can give you the exact rate. Sorry, apologies. So if we reduce that rate to the $898, and that's for a 10 plus year practitioner. And I'll leave you to sort out the sums on that. So I would reduce the phone call, specifically the one long phone call. And then in terms of the amount that follows for the emails to Mr. Montague Smith, I would also increase or decrease these to the 898 rate.
Can I just check the 898 rate? What's that taken from? Because
that's from the registrar's. That's from the registrar's direction number 1 of 2023.
Yeah, because I think the issue that arises in this case is that the partner rates and senior associate rates change, and also the rates claimed are not the same as the registry rates. So, for example, Ms. Roshan's rate up to the 1st of January 24 is 795 and then goes up to 935. And if there was a reduction in principal of her rate, the way to do it would be for her rate to go from 795 to 760, which would be the senior associate rate at White and Case, or from 935 to 825. So if you look at page 9. That's
why I asked at the beginning. Was Ms. Roshan at the time charging at the partner rate for the telephone call? That was my question.
It may be that I misunderstood your question, Registrar, for which apologies. So the answer to that is, at the time of the telephone call, she was charging at, one can see her rates at page 9 of the bundle. Prior to the 1st of January 2024, she was charging $795, or the firm was charging $795 per hour. And then post the 1st of Jan 2024 is $935. So at the time of that specific telephone call, it would have been $795.
Right, then I would leave it at that rate, although I will at the very end reduce the overhead amount. So I'm going to reduce the entries in terms of time entries. Instead of looking at the figure, I'm going to reduce those by 30%.
Could I check, Registrar, which entries that 30% reduction applies?
So these are entries on the attendances on council.
Yes, so it's the entirety of the attendances on council. Thank you.
Sorry, and just checking, Miss Levy is right. Okay.
She was a junior associate and then a mid-level associate.
All right. Yeah, on her rates are fine.
Thank you, Registrar. I think that deals then with point 7. We then have 3 points left to go, and I think we can probably group the last 2 together. Point 8 is the next one. So that's at page 57 of the bundle. And it's a short point of dispute, thankfully. And it only relates to the point on service, which I've already addressed you on. And I can deal with it without really turning to the bill of costs. The attendances on Egyptian lawyers relate to service in Egypt They do not relate to alternative service applications serviced by email. So that is a point which is simply not borne out based on the work that was done on the judge's cost order. We accept that we're not entitled to the cost of the alternative service applications, but we are entitled to the cost of service in Egypt, which this relates to. And it's as short as that.
Mr. Doherty?
Yes, so in relation to this, what we suggest is that the approach ought to be consistent with what we've addressed as the work done on documents in connection with this issue, where you've made the 30% reduction. This is attendances on the same issue, and so the similar principle should apply.
I agree. I would apply a 30% reduction here.
I should say earlier I addressed you on point 9 insofar as there were the common issues with point 6. So those were the work on the Part 7 proceedings, the work on the IP issues, and the work on service-related issues. Mr. Jackson, who I will have observed and addressed in his skeleton, there are a number of separate points which deal with work on documents, which remain to be covered in respect to point 9. So, for example, that's items in relation to duplication of work on skeleton, work in relation to work carried out by partner and mid-level associates on bundling, and costs post-dating the 15th of April. So that's items 3, 4, 5 in the points of dispute point 9.
Yeah.
And then there's also point 7, which deals with work carried out on the bill of costs as well. I don't know if Mr. Jackson wishes to address you on those points, or whether you wish me to address you first.
Well, I mean, I'd understood we dealt with point 9 because Mr. Doherty went first on that and I'd responded. But I think the approach you took on point 9, Registrar, was to reduce the figure by 30% across the board for the items we did consider. My understanding of your approach so far is that that's likely to be the approach that's sensible for the remaining points in point 9 as well. So that's the approach I would suggest the court adopts. In relation to the bill of cost, I mean, it may be sensible for us to leave that and come back.
I would leave that to the end. I would like to be addressed on the bundling issue. So this is item 4.9.
Yes, I can deal with that. So in relation to that issue, this is explained in the claimant's reply to the points of dispute. If you could go to page 59 of the bundle, and under subparagraph 4 of that, we explain why a partner and mid-level associate both prepared and updated the bundle for the hearing on the 14th of April 2024. That should be 15th of April. The hearing took place immediately after the Eid al-Fitr holidays, and the associate in question is Muslim and was therefore not available as a result of the religious holiday at times. So essentially the work had to be split, and that was something that couldn't reasonably be avoided. And the partner had to have some level of involvement given her familiarity and knowledge of the case. So that's the reason for that. And we say in those circumstances that amount should be allowed, but subject to the overall reduction of 30% if you registrar are minded to make that reduction.
I would maintain the reduction, but I still have concerns of our partner preparing a bundle. Are we still talking about Mr. Shan's rate? I'm assuming this is the updated rate. So this is the $935 rate.
Yes, that would be, because it's after after the
1st of January.
Yeah.
Right. I would reduce her rate to that of a mid-level associate, because that's who would have done it if it wasn't for the Eid al-Fitr holidays, and still maintain the reduction.
Yes. So if I can summarize where I think we've got to on point 9 then, Registrar, just so everyone's on the same page. As I understand it, there will be a 30% reduction across all items, and that's a reduction in terms of the overall cost.
Yeah.
And then in respect of the bundle preparation, that will also, prior to the reduction, be reduced to a mid-level associate in Ms. Roshan's case. And the mid-level associate rate, I gather that you had in mind, Registrar, is the one, again, in the indicative hourly rates in the Registrar's direction. So that would be $809.
$809, yeah, correct.
Thank you.
Apologies, Registrar. It may well be that when I was dealing with the common issues, what I meant to tell you was I was dealing with the issues that were common as between 6 and 9. I think you've covered the bundling issue and the approach overall on documents. There are other issues which relate to non-recoverability in their entirety as well, which arise from point 9. So, for example, that's the point taken about cost claimed which post-date the judge's order. So the judge's order was cost recoverable up to and including the 15th of April.
This is point 5, Mr. Doherty?
Yes, correct.
Okay. Sorry, item 5 of point 9.
But there are items in page 28 which post-date. So
if I can just be taken to the cost order again. I've lost the reference to it.
Yes, bear with me.
Never mind, I'm here.
It's page 101.
Right. Mr. Jackson, would you like to respond on that point in specific?
Yes. So as I understand it, the issue is taken with the 15th of May entries on page 28 of the bundle.
Right.
And hopefully this is helpful, but I'm happy to accept those 2 entries should be removed. They're relatively modest in any event.
And then the August entries relate to cost submissions, which we are going to discuss anyway. So we are discussing the 2 entries on 15th of May, and we can disallow those. It's about 54 minutes. Yep, sorry, yeah. 54. Yeah.
Yes.
Right.
I think then that completes point 9, and thankfully we're on to the last 2 points, which just relate to the bill of costs. So if I could show you the points of dispute briefly, Registrar. Point 10 starts on page 60 of the bundle. And what's said is that the costs of checking and approving the bill of costs are excessive, and that 2 senior solicitors for a total of 1.5 hours is not reasonable. And they say limit to 30 minutes for 1 senior associate. And then in relation to point 11, it said that the costs of the bill of costs itself is too high, particularly where and they say that there's been no meaningful work done as to how the costs break down. Now, I say that those points are wrong. The bill of costs is, as you've seen, a detailed document running to 22 pages and including numerous entries. That reflects the fact that it covers the entirety of the Part 8 proceedings, which, as I said earlier, lasted around 11 months. So looking at that and looking at it in context, I do say that the time spent and the costs incurred in relation to the bill of costs are reasonable and proportionate. Dealing with the figures specifically, in relation to the 1.5 hours for checking the bill of costs, that's a relatively modest amount of time. And of course, the bill of costs is a document that needs to be verified by a statement of truth. So it does need to be checked carefully. And 1.5 hours is, in my submission, entirely reasonable. As to the costs, £7,000 in my submission is not an excessive amount for this. Much of the work was done by a cost draftsman who is familiar with these types of documents that need to be produced. Obviously, it's their job to produce them. So in those circumstances, the time spent and the resulting costs incurred are in my submission reasonable.
Right. Mr. Doherty?
Yes, obviously, we disagree with the submission. We've got what we say are excessive amounts of work in both preparing and reviewing costs. Some of the work in relation to which would have been done prior to the 15th of April hearing anyway. So, for example, page 28, we have preparing the documents for the cost assessment, reviewing cost submissions, marking up invoices, and so on, totaling a substantial, we say, amount of work done on documents in connection with this issue. So in the region of 6.5 hours. And in addition to that, we have the further costs set out for preparing the bill at page 19 and page 20 in the bill of costs. And where one has disbursements of $7,000 for a draftsman spending a further 6.5 hours of solicitor time in relation to preparation, and in addition to the costs of checking set out in the bill of costs, we say on its face is excessive and disproportionate. We add to that a cost schedule had, of course, already been prepared for the 15th of April hearing. Some of the work in pulling together these costs will inevitably have already been done at that juncture. The level of detail here, and one can go by page count, but it's pretty clear if one looks at, for example, the majority of the page count we're dealing with here, which is Schedule 1, it's simply a printout of time entries that had been recorded, one assumes, contemporaneously, and then put into a schedule. That's not a substantial amount of work. The entries in the bill of costs document itself are not particularly detailed. Quite a lot of the detail that has been included is, for example, page 12. A page is taken up with copying and pasting in an order made by the court, but no meaningful additional work has gone into breaking costs down to anything more than basic descriptions. And in that context, we say both in respect of points 10 and 11 that the time spent on that is excessive.
Mr. Jackson?
And nothing by way of reply, Registrar.
I'm going to limit the hours of the senior solicitors for checking the bill from 1.5 hours to 1 hour. And so there were 2 senior solicitors doing this. I would limit it to one senior solicitor, 1 hour of their time. Moving on to the costs of the bill of costs, I will reduce this from $7,000 to about $5,500.
Thank you, Registrar. Could I just check on the first point? The 1 hour that's permitted for the one senior solicitor, is that applying that senior solicitor's claimed rate in the bill of costs?
Yes.
Thank you. I think that deals then with all of the points in dispute on the bill of costs, Registrar. Obviously, the parties will need to go away, and particularly my side will need to go away and prepare a revised bill of costs. You may have picked up in my skeleton that I had sought an order for the claimants to recover their costs of the detailed assessment proceedings, the bulk of which will relate to this hearing, but also the points of dispute and the points of reply that were filed. The usual rule is that the receiving party is entitled to their costs of the detailed assessment proceedings. The court can obviously depart from that rule. I would invite you to make the usual order that we are entitled to it. The alternative would be that the parties go away and make submissions on paper to you following this detailed assessment hearing. The reason why we invite you to make a ruling now is because it's obviously important that more costs aren't incurred arguing about costs. And it would be our submission sensible to try and draw a close to that issue.
Subject to anything Mr. Doherty says, I don't intend on departing from the general rule, and I would say that you are entitled to your costs. I do have a statement of costs before me. Yes, go ahead, Mr. Doherty.
I do obviously have points to make about that,
Yep.
which is the general rule in a detailed assessment is not quite as strong as the general rule when it comes to success in an application. The registrar, you of course have pretty broad powers when it comes to this. The reason that one ends up at a detailed assessment is because the costs being claimed were excessive, and we invite you to form the view that that was a correct position for the first defendant to maintain. The overall costs claimed here, 270,000, were excessive. They weren't justified by the schedule of cost, as the judge pointed out in his costs order, and it was appropriate for the first defendant to seek to contest those points as we've done. And in relation to the points that we have contested, there have been substantial reductions to the overall costs being made, both of work on documents, on attendances, and in respect of counsel's fees for attending the hearing. Had it not been for the position maintained by the first defendant, those reductions would not have been obtained. And when one looks at what is required by the court's rules and detailed assessment, you have a default provision, you have a power for the court to make some other order. But what Rule 40.45 says is, in deciding whether to make some other order, the court must have regard to the circumstances, including conduct. Well, first of all, there's no element of misconduct, clearly, on the part of the first defendant. It made points which were reasonable for it to make. Two, the amount, if any, by which the bill of costs has been reduced. Obviously, we're going to have to go away and do the arithmetic on that. But where we've been talking about 20 and 30% reductions, there's obviously a substantial proportion and extent to which the bill of costs has been reduced, and therefore the cost payable by the first defendant have been reduced based on arguments it quite reasonably made. And three, Rule 40.453 is the question of whether it's reasonable for a party to claim the costs of a particular item or to dispute that item. And we would invite you to conclude that it was plainly reasonable for us to dispute the items that we occupied our time dealing with during the course of this hearing. The stance of the first defendant in the face of a bill of $270,000 was reasonable. We took points that were open to us to take. And I suppose the point one would go to show the reasonableness of that position is the reflection of the judge himself when it came to the bill of costs, observing that the amount being claimed was a substantial amount for a short adjourned hearing and a Part 8 claim. And in those circumstances, there are plainly, we say, reasons to depart from the general rule. When it comes to the actual cost application itself, a schedule of costs wasn't actually filed until I think last night after 10 p.m. No doubt the claimant solicitors will be aware of the rules in Part 38 about making applications for costs, which is the statements of costs need to be filed and served as soon as possible, but in any event, not less than 24 hours before the hearing. And so there is no proper application for costs before you because we don't have a schedule of costs. We haven't had the time properly to consider the contents of the bill of costs. Of course, putting all else to one side, we haven't done the arithmetic and what the final figure of the reduction is. But even looking at the statement of costs at a high level, it's really very difficult to explain how the costs could be as high as they are. One can understand counsel disbursements for preparing a skeleton and attending the hearing. That explains 1/7 of the amount of costs claimed. What is wholly unclear is extensive attendances on opponents, on others, and extensive amounts of work being done on documents by fee earners, which appear to be separate to the costs that have already been incurred in preparing the bill of costs in connection with these proceedings, where the only document really filed is a response to the points of dispute. That's quite difficult to explain, but in any event, the first defendant has not been afforded a proper opportunity to consider those costs in any event. There's no proper application before you. And so on that basis, the appropriate order to make is that there be no order as to costs.
If I can respond to those submissions, Registrar. The first point relates to the manner in which the first defendant has disputed the bill of costs. A substantial amount of time has been taken up in the points of dispute, in the points of reply, in the skeletons, and at this hearing, in relation to points which the first defendant was not entitled to run because of the effect of the judge's costs order. But we took almost the first hour of this hearing dealing with the point of principle, which is whether the first defendant could say, well, you're not entitled to the costs of the set-aside claim, even if they fall within the Part 8 phase. And that's a point we've had to come back to time and time again. And with respect to the first defendant, it has wasted a lot of court time and a lot of resources of the parties in circumstances where there was a very simple answer to it and a very simple interpretation of the judge's order. So that's the first point. In relation to the points of dispute that the first defendant raised on reasonableness and proportionality, in a lot of the points of dispute, as we've seen as we've gone through them, specific reductions were not proposed. What were made were general complaints about things being excessive or things being too high, without actually any granularity as to what level the first defendant was saying the cost should be reduced to. And that, again, is not a productive way to engage in a detailed assessment process, because one doesn't know what target you're aiming at. Now, in relation to the actual reductions that you've made, Registrar, I acknowledge that you've made some reductions, but they are, in my submission, relatively modest. What the first defendant was saying, for example, in respect of service, was, well, you should cut out all of the service items in the bill of costs, and the same for the IP issues, and the same for drafting the particulars of claim. And that is not the approach you've adopted. You said that those items should remain with a relatively modest reduction. And the same applies to counsel's fees for the hearings, where the first defendant said, well, we shouldn't be entitled to recover those at all because they're purely duplicative, say for a refresher. And you found that they were recoverable, subject to a reduction of around 20%. So there are relatively modest reductions in the grand scheme of things. And we obviously need to work out the numbers, but one can get a sense of what the size of the reductions is from the percentages. So there's no basis for my learned friend's submission that the reductions have been substantial. In terms of the line items in the statement of costs that we filed, I mentioned this in my opening submissions on costs, that a lot of that work, particularly the work on documents, attendance on opponents, will relate to the points of dispute and the points of reply. There's also been some correspondence in relation to trying to agree a figure to avoid the need for detailed assessment. So I suspect that covers some of the attendance on opponents. The work on documents, which is a lot of the work, has been caused by the points of dispute and the points of reply. As I say, that probably goes more to the assessment and the summary assessment of those figures, rather than whether the court should make an order. The only other point that my learned friend raised was that he said there was no proper application before you for a summary assessment of costs. Well, just to be clear, the rule in the RDC requires that a statement of costs is served 24 hours in advance of any essentially request for summary assessment. Now, I accept that the statement of costs was only served relatively late last night, but my learner friend has had notice of this point since my skeleton argument was served. And you can see that from paragraph 63 of my skeleton argument.
Sorry, paragraph 60?
63.
Right, yeah.
Where I specifically refer to the general rule that the receiving party is entitled to its cost of the detailed assessment proceedings, and say there's no reason to depart from it, and the claimants therefore will seek an order that the first defendant pay the claimant's cost of the detailed assessment proceedings summarily assessed. So the first defendant was well aware from around a week ago that we were going to seek a summary assessment of the cost of the detailed assessment proceedings. And the statement of costs, which was served yesterday, it's not a long document. My learned friend is well able and well capable of making submissions on it. In my submission, therefore, the appropriate order for the court to make, following the general rule and to avoid further costs being incurred arguing about costs, is for the court to order that the claimants are entitled to their cost of the detailed assessment and to summarily assess those costs.
I don't intend to depart from the general rule. The claimants are entitled to their costs. I'm just looking briefly through the statement of costs that was submitted. Mr. Jackson, there's an entry here, or section here that says attendances on others. Could you clarify what these relate to?
I believe that will relate to the court, but if I can just take instructions on that.
Right.
I've just asked my instructing solicitors. I'm sure they'll get back to me shortly. Apologies, Registrar. I think they are having a... Yes, I understand that it's attendances on the registry.
There are two entries here for Miss Albulaihid.
Yes.
And they're at different rates. So I'm just a bit confused as to what each of these entries relates to and why, or the amount of time spent on attendances of the registry, I think, which would have been a very straightforward matter.
In relation to the rates, that reflects, one would assume, a promotion in her seniority. In relation to the time spent, the overall time, as I make it, yes, she's just confirmed it's different levels of associate. So I think she was a junior associate before and then promoted to a mid-level associate. In relation to the overall time spent, it comes to 1 hour, 36 minutes. I can take instructions on what that specifically relates to.
If you could, yeah. Just because it would concern me if the registry has been spending this much time.
Yeah, I acknowledge that. They need to check.
Right.
Perhaps I can confirm that a bit later on, so as not to delay us.
All right. So I think your costs, so the council costs, in my opinion, I think are reasonable, so I'd allow them. That leaves us with an amount of That's about 62,467.
I should also say, Registrar, attendances on others. I missed the obvious point that would also include attendances on council.
All right. No, that makes sense.
So that, apologies for that.
Right. Okay, so I'm going to take this figure down. Sorry.
Sorry, Registrar, which figures are we talking about? Because I obviously have points to make on figures anyway.
Okay, would you like to make that, Mr. Doherty?
Yeah, well, there are quite a few. I have to say, I was sent this at 10 p.m. last night. There are elements of this schedule of costs which I find concerning and which I think, Registrar, you should find to be particularly concerning as well. I'll go through some of the traditional ones, but it's pretty careless, if I can put it in those frank terms. For example, attendances on opponents, entry 4, Miss Roshan, 30 minutes, is being totaled at $31,350. So one cannot have particularly strong confidence that this schedule of cost has been properly prepared at all. One assumes that's a calculation error. That can be the only realistic justification that someone there has charged 30 hours at 1,045 rather than 30 minutes. But that's a pretty extraordinary error to make on a schedule of costs where you're turning up to court, having filed it at 10 p.m. last night, asking for a grand total of $73,712 in recoverable cost of a detailed assessment. And the broader point one makes is that one should really question what goes behind these figures that are claimed under other headings. So that's obviously a pretty fundamental point to make right at the outset. The second point, of course, relates to the rates charged, which we say are excessive. There's no real rationale as to why these figures are substantially higher than the equivalent rates that we've been looking at in the bill of costs. For example, the associate rate is now in effect what the higher end partner rate was when we looked at the bill of costs. And the partner rate itself has jumped up to over $1,000, and those rates are excessive to the extent that they are to be granted in any way. They should be limited to the rates that were set out in the bill of costs. So that's the second point. The third point is there are extraordinary time costs claimed here, even putting aside the obvious errors. Attendances and opponents exceeds 3 hours. There's no explanation on that. There has not been any particularly extensive correspondence between the parties which would justify that amount of time having been spent. There's no explanation of why a new associate has been involved in 24 minutes of that time, having not had any prior extensive involvement in the case. The extremely surprising amount of work done is the almost 25 hours spent on documents. That's respectfully pretty inexplicable. If one just looks at it, the sole document that would have had input from solicitors as opposed to counsel is the points of dispute at page 48. Sorry, the reply to the points of dispute at page 48 of the bundle. This document itself runs to a total of 12 pages. But if one looks at the format of the document, so for example, if one goes to page 52, one can see the table form that it's set out in. But for example, at page 52, the words actually drafted by the claimants occupy about a third of that page. Over the page again, you see the same point. The claimants' replies occupy approximately half of this document. So if you look at the actual work product that's being churned out in this 12-page document, if you can say generously that 50% of it are words that are actually drafted by the claimant solicitors, they've spent 25 hours, we're told, on that. And that is an excessive amount of time to be spending on documents for a detailed assessment hearing, particularly whereas we've already looked at the actual work that was being carried out, which was the preparation of the bill of costs, preparation of cost schedules, instructing cost draftsmen, and so on. Those are incurred on top of this as well. Given the nature in which this document has been put together, the proposal on the amount of costs we would suggest would be appropriate are, one, limiting the recoverable costs, we say, to council's fees, because one cannot have any proper faith that this cost schedule has been properly prepared in light of the error made in line 4. But as a backup to that position, what one would need to do is, first of all, excise this line item for $31,000 completely. One would need to substantially reduce the amount of time that's recoverable for work on documents and work on attendances at the outset. And given the excessive amounts claimed, reducing that amount of time and the basis that it was excessive, we would say would be appropriate at 50% in and of itself. And then beyond that, when one gets to quantifying the total of the bill, it would be entirely appropriate to make further reductions on the basis that ultimately the first defendant was successful in resisting particular issues and getting reductions in certain issues. So it would be to reflect the measures of success of the parties. But quite clearly, we're talking about an overall bill of cost that is substantially lower than what's set out there.
Right, Mr. Jackson, anything to say in response?
Just very briefly. So first of all, on the 30 minutes versus 30 hours point, I accept, of course, that that's an error, and I'm grateful to Mr. Doherty for pointing it out. That I'm instructed by my solicitors that they put 30 minutes in, and that the form usually automatically calculates what the final figure should be in terms of the cost. I'm not sure what's gone wrong there, but clearly that needs to be amended. 30 minutes is the correct amount, and one can then apply Ms. Roshan's rate to that to give a correct figure. But that doesn't mean that the assessment can't go ahead, nor does it mean, as Mr. Doherty suggested, that somehow the entirety of the bill of costs is open to criticism. He hasn't pointed to any other part of the bill of the statement of costs, rather, where there is any other error. So in my submission, the appropriate thing for the court to do is to amend that error and then proceed to assess the remainder of the statement of costs on the basis that it has to be reasonable and proportionate. That's the appropriate way to proceed. It doesn't mean that one can't do the assessment. The second point I want to make is that Mr. Doherty suggested that rates should be limited to the same rates as set out in the bill of costs that we looked at for detailed assessment. There's no basis for that. Rates obviously increase over time. That's a natural part of solicitors progressing in their profession. So it is appropriate to use the rates that are set out in the statement of costs, because those are the current rates. If the court considers it fit to make a reduction to the figures in order to make them reasonable and proportionate, that's another thing. But what it shouldn't do is just revert to the rates that are set out in the bill of costs for detailed assessment. And finally, on the time spent, attendance on opponents, there have been a few different aspects to the attendance on opponents. First of all, there was the correspondence seeking to agree the cost figure that should be paid on the detailed assessment to avoid the need for detailed assessment. Secondly, you may be aware, Registrar, that there was a request for an extension of time for the filing of the first defendant's skeleton argument, and there was correspondence between the parties on that. And thirdly, there was some correspondence relating to what documents should be included in the bundle. We said the bundle should be a much more slimline version. The first defendant wanted a number of additional documents included. So that is the reason why there are that many hours of attendances on opponents. And in terms of the work on documents, it's not correct, as Mr. Doherty suggested, that purely concerns the points of reply that were drafted by the claimants. Obviously, in formulating the points of reply, one has to consider the points of dispute that are raised as well and go through them carefully. So that also should be taken into account. And it would also include a review and input on counsel's skeleton argument, although I accept that part of it will be relatively modest because that's primarily a job for counsel.
Right, so I think the error in the form, it does not factor into the ultimate amount in the grand total. I'm just trying to work it out quickly, but I don't think it does. Yeah, actually it does. So if we were to reduce that amount or take it out, 3,350. And then Miss Roshan's rate at the time, if you could, so 1045, so that brings us to 31,638.5.
Forgive me, Registrar.
What I've done is I've just added up the total amounts on the right for all of these, for all the attendances and work done.
Yes.
And that's taken me, and I've reduced Ms. Roshan's rate here to where the system seems to have calculated it to be 31,350, and that's been a massive jump. So I've taken that out and added the correct rate, which is half of her, half of the rate that was placed here. So half of the 1,045, I've added 522.5 because she's put in 30 minutes on these attendances, and that's taken the figure down to 31,638.5.
Yes, I'm just double checking that, but I'm
yes, if you could.
Sure. Registrar, would you mind giving me your figure again?
31,638.5.
Yes. That's what I get as well.
Sir Doherty, are you also trying to calculate alongside us just to make sure we're all on the same page?
Yes, I'm in the middle of doing a run through.
Okay.
Yeah, so this is dealing with the the total, simply taking off the 31350 and including a. Yeah, I think
Adjusting.
I've got the same figure, so that's before adjustments and dealing with the submissions. Yeah,
And before council's fee as well.
Yeah. So not looking at council fees because I've found that to be recoverable.
Yeah.
I am just looking at the 31,638.5 figure, and I'm going to reduce that to 25,000. That's a 20%, slightly over 20% reduction.
I'm grateful, Registrar. So the total amount payable then would be $31,245 by my calculation.
Right. So that leaves the matter of today's costs. Sorry, no.
But that includes today's
Yeah,
costs,
yeah.
Registrar.
Sorry, not today's costs. So what we're waiting to see from you, Mr. Jackson, is the adjusted figures.
Yes, correct. So my side will need to file an updated bill of costs for your approval, and I think then the process is that the registrar will produce a final cost certificate. The only exception to that is the cost of the detailed assessment. I think those would usually be dealt with by way of an order in the usual way. In terms of the time for payment, the time for payment is usually 14 days. What I was, that's the time for payment that we seek. Subject to that, if it assists registrar, I'm sure the parties could draw up an order for your approval.
Mr. Doherty, anything to say for the period of time of payment?
No, I understand the process. Mr. Jackson, his solicitors are going to perform. I'll wait a copy of the draft order, which the first defendant will review, and we can get it to registrar.
All right. Anything else?
And nothing from our side, registrar. Thank you for sitting beyond the hours.
Mr. Doherty?
No, thank you. Thank you for
All
your time.
right. Thank you very much, gentlemen. Have a good day.
Thank you.